Senator Mraj, kindly take your seat. Proceed, Chairperson.
Thank you, Speaker. The Street Vendors and Protection and Livelihood Bill 2023 is a bill for an act of Parliament to provide a legal framework for the recognition, protections and regulations of street vendors in Kenya, the identifications of minimum standards for street vendors, and for connections purposes. Pursuant to the provision of Article 118 of the Constitution of and Standing Order 145(5) of the State Senate Standing Orders, the committee invited interested members of the public to submit their representations on the bill. They include the National Gender and Equality Commission, the Council of Governors, the Central Organization of Hawkers Association, associations of PWDs, street vendors, and Senator Crystal Asige. The status of the bill: the report was tabled in the Senate on Tuesday, 23rd of April 2024. Committee Cooperative Societies Amendment Bill 2023, Senate Bill number 53 of 2023. The Cooperative Societies Amendment Bill 2023, Senate Bill number 53 of 2023 was read the first time in the Senate on Tuesday, 29th February 2024, and subsequently referred to the Standing Committee on Trade, Industrialization, Tourism, and for considerations. The purpose of this bill is to amend various sections of the Cooperative Society Act in order to align the Act with the provisions of Part 2 of the 4th Schedule of the Constitutions that provide that cooperative development is a devolved function. Pursuant to the provisions of Article 118(b) 1(b) of the Constitution and Standing Order 145(5) of the Senate Standing Order, the committee invited interested members of the public to submit any representation that they may have on the bill by way of writing memorandum in the major dailies on 2nd March 2024. At the expiry of the public participation period, received a memorandum from Ministry of Cooperatives and MSMEs and the Council of Governors, respectively, who requested that the Senate bill be stepped down in favor of the National Assembly Bill 2024. Consequently, the bill invited the sponsor of the bill, Senator Mariam Omar, MP, for deliberations on the way forward on Tuesday, 23rd April 2024. The deliberations are ongoing. Petitions. The petition on the fraudulent shareholding activities and illegal activities of East Africa Breweries Limited, EABL. Mr. Speaker, sir, during the period under review, one petition was reported on 30th May 2023 by Senator Wakili Sigei, MP, on the fraudulent shareholding activities and illegal activities of East Africa Breweries Limited. The committee has undertaken extensive engagement with all the relevant stakeholders, including the petitioner, Mr. Nicholas Rono, and the Chief Executive Officer, CEO Capital Authority, CMA, Competition Authority of Kenya, and Revenue Authority of Kenya. The status: the committee is finalizing the draft report on the considerations and adoption. County visit. Mr. Speaker, sir, during the period the county undertook a report writing retreat on 23rd March 2024 in Machakos County to consider the following legislative business: meeting with stakeholders on the Street Vendors Protections and Livelihood Bill 2023, the Cooperative Societies Amendment Bill, Senate Bill number 53 of 2023, and pre-publication scrutiny on the Creative Economy Support Bill 2023. Further, on 16th and to 18th February 2024, the committee participated in a consultative shareholder workshop on the Cooperative Bill 2023-2024 in Machakos County. Statement. Mr. Speaker, sir, during the period under review, 7 statements were referred to the committee for consideration as follows. 1, a statement requested by Senator David Wakoli, MP, on 21st February 2024 regarding cooperative societies in Bungoma County. The status of the statement: the committee received written responses for the Ministry of Cooperatives and MSMEs on 22nd April 2024, which has been shared with the Senator David Wakoli. Statement requested by Senator Samson Cherargei, MP, on 22nd February 2024 regarding police raid on business in Eastleigh over counterfeit products. The status is that the statement is concluded and referred to the relevant committee. A statement requested by Senator Ledama Olekina, MP, on 28th February 2024 regarding the status of tourism and consequences lease agreement entered into the proprieties in the Greater Mara and Triangle in County Government of Narok. The status of the report of the statement is that the committee has requested and scheduled a meeting to meet the governor on 9th May 2024. Statement requested by Senator David Wakoli on 5th March 2024 regarding the collapse of Malakisi Cotton Generary Sirisia constituency, Bungoma County. The committee has received responses from the Ministry of Investment of Trade, and the statement is concluded. Mr. Speaker, sir, on the overall, as per the Senate statement tracker, the committee has received and processed 38 statements and concluded 24 statements. International engagements undertaken by the committee. Mr. Speaker, sir, during the period under review, the committee held a joint sitting with the National Assembly Department Committee of Trade and Cooperatives on Thursday, 21st March 2024, and facilitated the address by Wamkele Mene, the Secretary General of Africa Continental Free Trade Area, on the status of intra-Africa trade opportunities and economic cooperations. Challenges are encountered. Mr. Speaker, sir, the committee noted the concerns that there are 2 published bills on the cooperative societies in both houses. These are the Cooperative Societies Amendment Bill, Senate Bill number 53 of 2023, and the Cooperative Society Bill of National Assembly Bill number 7 of 2024. The 2 bills have similar shareholders with divergent views, which has affected public participation and stakeholders' engagement. Priorities of the committee for the quarter. Mr. Speaker, sir, the committee will prioritize the following business in the next quarter. One, undertake a report writing retreat on the following petitions of fraudulent stakeholders' activities in illegal acquisitions of East Africa Breweries Limited, the Cooperative Societies Amendment Bill number 53 of 2023. B, the committee to undertake an inspections visit to Embu and Meru counties to engage with Muguka and Miraa farmers and and the related farmers' activities, cooperative societies. The committee is to meet with the Metropolitan National Circle to conclude on the statement regarding by Senator David Wakoli, MP, on the status of Metropolitan Circle regarding the fraudulent of the shares and deposits of the withdrawal of the teachers and from the said circle in Bungoma County. And finally, the committee to undertake a country visit to assess the implementation status of county integrated industrial park in the county. Thank you, Honorable Speaker. Thank you very much.
Now, honorable senators, we will defer the last two statements and Standing Order 56-1B as listed in the order paper, and straight away move to prosecute order number 8, 9, and 10. Clerk, proceed to call that order, please. A correction, honorable senators, we will proceed to take order number 8 and 9 at the Committee of the Whole.
Order number 8, Committee of the Whole. The County Boundaries Bill, Senate Bills number 6 of 2023. Order number 9, Committee of the Whole. The Sugar Bill, National Assembly Bills number 34 of 2022.
Order, senators. We want to do serious business. Senator Mgatana, Senator Kajwang. Honorable senators, we are starting with the County Boundaries Bill, Senate Bills number 6 of 2023.
Clause 3.
I propose the question that Clause 3 be part of the bill. I put the question that Clause 3 be part of the bill. Division at the end.
Clause 4.
I propose the question that clause 4 be part of the bill. Chair, Standing Committee on Devolution.
Njata, give Senator Bass the mic.
Okay. Honorable Speaker, I propose that in in clause 4, bill be amended in subclause 1 by deleting the word electronic appearing immediately after the words and up to date and substituting therefore the word digital and manual. B, in subclause 2 by deleting the words utilize the appropriate technology to ensure appearing immediately after the words under section 1 and substituting therefore the words ensure appropriate technology is utilized for.
Any further explanation?
Yes, I have rationale. This is to ensure that the, sorry?
Yes, proceed.
Yes, this is to ensure that the Cabinet Secretary does not only keep electronic records of the boundaries of each county, but instead keeps both digital and manual record of the boundaries for each county. This will enable the citizens in the country to verify the digital and manual records of the boundaries of different counties. I urge members to support these amendments.
Okay, Honorable Senators, I propose the question that clause 4 be amended as proposed. And see to Senator Gloria Oroba. Are you interested to make a comment on this proposed amendment? You are not aware. So I put the question that clause 4 be amended as proposed. Division at the end.
Clause 5.
I propose the question that clause 5 be part of the bill. Chairperson.
Honorable Speaker, Honorable Chair, that clause 5 of the bill be amended in clause 2A by inserting the word committee immediately after the words county executive. That was omitted initially. Rationale, the purpose of this amendment is to clean up the text.
Okay, I propose the question that clause 5 be amended as proposed. I put the question that clause 5 be amended as proposed, division at the end.
Clause 6.
I propose the question that clause 6 be part of the bill. I put the question that clause 6 be part of the bill. Division at the end.
Clause 7.
I propose the question that clause 7 be part of the bill. Chairperson, you have an amendment?
Yes, Honorable Speaker, that clause 9 of the bill be amended, clause 7, that clause 9 of the bill be amended in clause 1 by?
Clause 7.
Clause 7, sorry. Yeah, I think this is actually the typo error, that the clause 7 of the bill be amended in clause 1 by deleting the words experience in alternative dispute resolution and substituting therefore the words post-admission experience and accredited mediator in this paragraph. Honorable Chair, the purpose of this amendment is to provide for the qualification of the chairperson of the mediation committee. The bill refers to experience in alternative dispute resolution. However, there are different forms of alternative disputes resolution being negotiation, arbitration, mediation. The intention of the bill is to establish a specific mediation committee, and as such, the committee recommends that the experience be specific and propose an accredited mediator. I urge members to support this amendment.
I propose the question that clause 7 be amended as proposed. I put the question that clause 7 be amended as proposed.
There's also B, Chair.
There is a B.
Yes.
Clause 7B.
He's spoken to part A.
Part B. Okay,
But B,
proceed.
yeah. B, inserting the following new paragraphs immediately after. But this is a new paragraph. I think it will come later. It's a new.
Yes?
It's a new amendment, I mean, a new paragraph.
Have you learned the new paragraph, DA?
And B, yes.
Oh, okay, good. So I put the question that clause 7 be amended as proposed. Division at the end.
Clauses 8 and 9.
I propose the question that clauses 8 and 9 be part of the bill. I put the question that clause 8 and 9 be part of the bill. Division at the end.
Clause 10.
I propose the question that clause 10 be part of the bill. Chairperson,
Chair, I propose, that clause 10 of the bill be amended in the proviso clause 1 by deleting the word fiscal planning or appearing immediately after the words experience in and substituting therefore the word mapping and. The rationale is that this is an amendment to make the technical person be fit to purpose, for the purpose. Technical expertise in survey and mapping is desirable and relevant for this purpose. I urge members to support the amendment.
honorable members, I propose the question that clause 10 be amended as proposed. I put the question that clause 10 be amended as proposed.
Clauses 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, and 22.
Honorable members, I propose the question that clauses 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, and 22 be part of the bill. I put the question that clauses 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, and 22 be part of the bill. Division at the end.
Clause 23.
I propose the question that clause 23 be part of the bill. Chairperson, you
Chair,
have an amendment?
That clause 23 of the bill be amended by deleting the word nominate, appearing immediately after the word receipt of the petition, and substituting it, therefore, the word appoint. Honorable Speaker, Honorable Chair, this is actually an amendment to use the appropriate words in the context. It is to provide for the role of the President in the appointment of the Commission. The role of the President is to appoint and not to nominate at that point. The President appoints the Commissioners, does not nominate them. I urge the members to support this amendment.
I propose the question that clause 23 be amended as proposed. I put the question that clause 23 be amended as proposed. Division at the end.
Clause 24.
I propose the question that clause 24 be part of the bill. Chairperson,
Honorable Chair, that clause 24 of the bill be amended in subclause 1 by deleting the words and fiscal planning appearing immediately after the words matters related to, and substituting, therefore, the words surveying and mapping in the paragraph D.
I propose the question that clause 24 be amended as proposed. I put the question that clause 24 be amended as proposed. Division at the end.
Clause 25.
I propose the question that clause 25 be part of the bill. Chairperson,
Honorable Chair, that clause 25 of the bill be amended in subclause 2C by inserting the following new subparagraphs immediately after subparagraph 2 and 3. Land survey and fiscal planning, and the rationale. This is on qualification to be appointed as a member of the Commission to include land survey and fiscal planning, which is a critical component of the role of the Commission. It is on that note that the professional in land survey and fiscal planning be considered as they have a critical skill required on boundary disputes. I urge members to support this amendment.
Silence means they have supported. So I propose the question that clause 25 be amended as proposed. I put the question that clause 25 be amended as proposed, division at the end.
Clauses 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, and 40.
Sorry, Senator Mugatana.
Yes, Mr. Speaker, it's okay? Just move it. Okay, thank you, Mr. Speaker.
Okay, so, okay. Clauses, I propose the question that clauses 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, and 40 be part of the bill. I put the question that clauses 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, and 40 be part of the bill. Division at the end.
Now for the next clause, which is clause. Clause 41.
I propose the question that clause 41 be part of the bill. Chairperson's amendment.
Honorable Chair, clause 42 of the bill be amended by renumbering the existing subclause 6 as subclause 2. The rationale that this is a correct drafting error. I urge members to support.
I don't think he's done. He's read the right amendment. You may ask him whether.
Clause 41, Chair.
41, sorry. 41, sorry, the question jumped. 41, that clause 41 of the bill be amended in subclause 4B2 by deleting the word commissions and substituting this, therefore, the word ministry. The rationale of the report of the commission should be circulated nationwide, keeping in mind that the commission is an ad hoc in nature and will be for a specific period. And in the interest of the information, it will be better to publish the report on the website of the ministry as opposed to that of the commission. The ministry has a role in keeping the records of the country's boundary, the county boundaries, and as such, it will be important for the ministry to be a custodian of the report as it is the primary office keeping records for county boundaries. I urge members to support the amendment.
Okay, there is also an amendment to the same clause 41.
Mr. Speaker, I also wish to further propose that clause 41 of the bill be amended in subclause 1 by inserting the words including matters touching on displacement of persons and compensation for loss suffered, end of quote, immediately after the words considers necessary, end of quote, in paragraph F. And Mr. Speaker, it is an amendment that I have been persuaded by Senator Danson Mugatana, the senator for Tana River, that would make the bill neater and would ensure that those functions and provisions under clause 41 are expanded, and there'll be a further amendment to clause 42, but then I wish to beg and move that the clause be amended in subclause 1, paragraph F, as stated. Thank you.
So, Honorable Senators, I propose the question that clause 41, as amended by the chair committee and the move of the bill, as be amended as proposed. I put the question that clause 41 be amended as proposed. Division at the end. Also, clause 42.
Clause 42.
I propose the question that clause 42 be part of the bill. There are two amendments by the chairperson and also the move of the bill.
Yeah.
So we start with the chairperson.
Yeah, Honorable Speaker, I think that clause 42B, 42 of the bill be amended by renumbering the existing subclause 6 as subclause 2B, amending the new renumbered subclause 2 by deleting the words the specific geographical appearing immediately after the words under subsection 1 and substituting therefore the words as comprehensive description of boundary with adequately enlarged scaled map. The rationale is that this is an amendment to ensure that we have all comprehensive descriptions of the boundary as possible. I urge members to support the amendment.
Let's get the further amendment by the Senator Moses Kajwang.
Mr. Speaker, I also beg to move that clause 42 of the bill be amended in subclause 1 by inserting the words, and I quote, including referring a matter to a relevant body for redress, end of quote, immediately after the words, and I quote, may consider appropriate, end of quote, in paragraph B2. Mr. Speaker, again, I have consulted with the veteran Member of Parliament, Senator Danson Mungatana of Tana River, and we have agreed that this amendment would ensure that this bill achieves the intended objective of ensuring that matters that are put before the mediation committee are appropriately handled. Thank you, Mr. Speaker.
I propose the question that clause 42 be amended as proposed by the chair and the move of the bill. I put the question that clause 42 be amended as proposed, division at the end.
Clauses 43 and 44.
I propose the question that clauses 43 and 44 be part of the bill. I put the question that clause 43 and 44 be part of the bill, division at the end.
Clause 45.
I propose the question that clause 45 be part of the bill. Chairperson.
Honorable Chair, that clause 45 of the bill be amended in subclause 1 by deleting the word may appearing immediately after the words Cabinet Secretary and substituting therefore the word shall within the years of coming into enforce of this act. So that shall within 2 years of coming into force for this act. So the rationale is that this is an amendment to the mandatory requirement by the Cabinet Secretary to gazette the regulations as opposed to giving the Cabinet Secretary the option to gazette the regulations. Therefore, I request members to support. There's also B, Honorable Chair, by renumbering the existing B, by renumbering the existing subclause 14 and subclause 2. This is to actually correct the drafted error. C also, there's also C. And the renumbered subclause 2 by inserting the words the Council of Governors immediately after the words Boundaries Commission. The rationale is that this is an important amendment to include Council of Governors as bodies to be consulted by Cabinet Secretary in coming up with the regulations. County boundaries are within counties which are manned by the county governors. As such, it will be important to have the council consulted in coming up with regulations as they are integral stakeholders. I urge members to to support the amendment.
Honorable Senators, I propose the question that clause 45 be amended as proposed. I put the question that clause 45 be amended as proposed, division at the end.
Clauses 46, 47, 48, 49, 50, 51, and 52.
I propose the question that clauses 46, 47, 48, 49, 50, 51, and 52 be part of the bill. I put the question that clauses 46, 47, 48, 49, 50, 51, and 52 be part of the bill, division at the end.
First schedule, second schedule, third schedule, fourth schedule, and fifth schedule.
I propose the question that the first schedule, second schedule, third schedule, fourth schedule, and fifth schedule be part of the bill. I put the question that the first schedule, second schedule, third schedule, fourth schedule, and fifth schedule be part of the bill, division at the end.
New clause 13A.
Senator Kajwang Moses.
Mr. Speaker, I beg to move that the bill be amended by inserting the following new clause immediately after clause 13, 13A, where in the course of mediating a boundary dispute, a matter touching on A, displacement of persons, B, compensation for loss suffered, or C, any such related matter arises, a mediation committee may make appropriate recommendations and refer the matter to a relevant body for redress. Mr. Speaker, again, I have been convinced by Senator Danson Mungatana on the need for this amendment because Clause 13 addresses the report of the mediation committee and it provides that the report shall be sent to the Senate or where it proposes alteration of a boundary to the Senate, National Assembly, and to the President. What this Clause 13A opens up is that the report should not be limited to the legislature and the executive, but the mediating committee can be allowed to refer their recommendations to other bodies like the National Land Commission, if there's compensation on issues of land, the Kenya Wildlife Service, if there's loss of life as a result of wildlife and human conflict across borders. And Mr. Speaker, I feel that this is a reasonable amendment that will not mutilate the intention of the bill. And I want to request Senator Mungatana to second.
Clear that clause 13A be read a second time.
Sorry, Senator Kajwang, just put it straight that new clause 13A be read the second time. That will suffice.
Thank you, Mr. Speaker. I beg to move that the new clause 13A be read a second time.
Thank you.
No need for seconding.
No need for seconding, that is. I propose the question that the new clause 13A be read a second time. I put the question that clause 13A, that the new clause 13A be read the second time. Division at the end.
Clause 2.
I propose the question that clause 2 be part of the bill. Chairperson?
Honorable Chair, that clause 2 of the bill be amended by deleting the words and fiscal planning and substituting that for, therefore, the words surveying and mapping in the definition of the word county secretary. The rationale, the technical expertise of the required for the determination of county boundaries relates to surveying and mapping more than fiscal planning. Therefore, the cabinet secretary ought to be one that is in charge of surveying and mapping functions in the country. I urge members to support this amendment.
Honourable members, I propose the question that clause 2 be amended as proposed. I put the question that clause 2 be amended as proposed, division at the end.
The title and clause 1.
Before you move, sorry, there's also B for that clause. B is that,
Go ahead.
is that B there? Okay, Chair, B, by deleting the words and fiscal planning, appearing immediately after the words matters relating to, and substituting, therefore, the words surveying and mapping in the definition of the term county executive committee member. That's B of the 2. Rationale is that the technical expertise required for determination of the county boundaries relates to surveying and mapping more than the fiscal planning. Therefore, the cabinet secretary ought to be, I think, the same thing.
So I put the question, I propose the question that clause 2B be amended as proposed. I put the question that clause 2B be amended as proposed, division at the end.
The title and clause 1.
I propose the question that the title and clause 1 be part of the bill. I put the question.
In that, there is also the new clause 7B, which is new. Clause 7B, inserting the following new paragraph immediately.
But that was an amendment.
Yes. No, it's a new thing. Inserting the new paragraph. Yeah, it's a new paragraph.
We are done with that.
Okay, thank you. Okay.
The title and clause 1.
I propose the question that the title and clause 1 be part of the bill. I put the question that the title and clause 1 be part of the bill, division at the end.
But it's important to put it into record that Senator Kajwang's amendments.
Honorable Senators, note that Senator Kajwangi's amendments were circulated. They were not on the order paper, but they were circulated for the record purposes. Now we are done with the county boundaries bill, Senate Bills number 6 of 2023. We are now on the committee of the whole. Sugar? Yeah. On the sugar bill, National Assembly Bills number 34 of 2022.
Clauses 3, 4, and 5.
I propose the question that clauses 3, 4, and 5 be part of the bill. I put the question that clauses 3, 4, and 5 be part of the bill, division at the end.
Clause 6.
I propose the question that clause 6 be part of the bill. Chairperson, Agriculture. Or any member with the amendments? Clause 6? No, from the committee. The committee's amendments. Senator Morango.
Thank you, Chair. Mr. Chairman, I beg to move the amendment as indicated on Bill number 34 of 2022. On order paper, as it's on the order paper.
Thank you.
Thank you.
Senator Wakori is a member of the Agriculture Committee and is moving the amendment on behalf of the chairperson.
Thank you.
Therefore, I propose the question that clause 6 be amended as proposed. I put the question that clause 6 be amended as proposed, revision at the end.
Clauses 7, 8, 9, 10, 11, 12, 13, 14, 15, and 16.
Yes, Senator Ososi.
Mr. Speaker, this sugar bill is a very important legislation, especially for members coming from western part of Kenya. I think for every amendment, it will be desirous that the mover explains the justification of that amendment so that we get to understand what we are amending.
Your concern is noted, Senator Ososi.
Okay.
Since I put the question, then that can be provided as we move along. You'll be satisfied with the explanation. Let's go to the next clause. Did you read this?
Yes, I did. Yes.
So I propose the question that clauses 7, 8, 9, 10, 11, 12, 13, 14, 15, and 16 be part of the bill. Senator Lekina?
Not yet. There is no amendment.
Oh, okay, okay.
Yes.
You know, I thought you wanted to give some input on the clauses. I put the question that clauses 7, 8, 9, 10, 11, 12, 13, 14, 15, and 16 be part of the bill. Division at the end.
Clause 17.
I propose the question that clause 17 be part of the bill. Chairperson? Senator Matinga?
I propose that clause 17, that the bill be amended by inserting the following new heading immediately after clause 17. Just a minute, just a minute.
Yes, Senator Matinga.
Chair, I beg your pardon for that. I propose that the bill be amended by inserting the following new heading immediately after clause 17, part 3, licensing and registration.
I propose the question that clause 17 be part of the bill. No, sorry. I propose the question that clause 17 be amended as proposed. I put the question that clause 17 be amended as proposed. Division at the end.
Clause 18.
I propose the question that clause 18 be part of the bill. I put the question that clause 18 be part of the bill. Division at the end.
Clause 19.
I propose the question that clause 19 be part of the bill. Chair, Agriculture, Matinga. On behalf of the chair.
Chair, I propose that clause 19 of the bill be amended by A, deleting subclause 1 and substituting therefore the following new subclause. 1, a miller shall not purchase sugar crop from or accept sugar crop delivered by a grower, and a grower shall not sell or deliver sugar crop to a miller unless the grower is registered with, has in force a valid supply agreement with the miller. B, factory of the miller is situated within the grower's sugarcane zone. Or C, grower is exempted from the requirement by the board under section 19A. And B, deleting the heading appearing immediately after subclause 3.
Propose first.
I propose the question that clause 19 be amended as proposed. Senator Chalge.
Chair, the intent of clause number 19, of course, I agree that, in cane development, there are millers who develop cane, and there is agreement with the farmer, and therefore it will protect and ensure that there is no cane hawking or cane poaching, Mr. Speaker or Mr. Chairman. It will ensure that the cane development is due done, Mr. Speaker, Mr. Chairman. Of course, there should be supply valid agreement. This is to protect also the growth of miller, Mr. Speaker, because most of the farmers have taken check-off, have taken loans from specific millers, so there will be protection by ensuring that there is valid supply agreement, Mr. Chairman. Chairman, on the issue of delivering within the sugar zone areas, will ensure there is discipline, because every game has rules, Mr. Speaker. For example, where I come from in Nandi County, Mr. Speaker, when you go to Nandi South, the nearest factory like Ibos, Moroni, and the rest is 18 kilometers, and we don't have a milling within Nandi County, for example. So it will ensure that within that sugar zone, it is easier for farmers within Nandi South to deliver to Kisumu factories which are there, and also from Kericho. Mr. Speaker, the unique when you come to Nandi North, is we don't, in Nandi North, we don't also have a miller. So it will be nearer to part of Upper Western, that is Kakamega, where Naitiri is, where Butali Sugar Company is, and it will ensure that farmers don't need to travel more than maybe 200 kilometers to deliver their cane, Mr. Speaker. So finally, Mr. Speaker, I think it is important that we have that where a farmer is, especially on that sugar zone. Because if we are growing to cluster, for example, as Oparanya report said, Mr. Speaker, sir, that we have central zone where you are having Nandi North, we're having Kisumu and Kericho, and maybe on Upper Western we're having Nandi South, Kericho and Kisumu. And then on this other part we have Nandi North, Kakamega, Bungoma, Trans Nzoia, because of proximity of those factories, Mr. Speaker. So agreeing with this, Mr. Speaker, it is in good faith and in ensure Ken development and protect also the interest of the farmer and the miller. I thank you, Mr. Speaker.
Honorable Senators, we'll just make a brief comment on that amendment. This bill was well canvassed during the second reading. Senator Buru Ondinga.
Mr. Chairman, I totally oppose this amendment. Mr. Chairman, the reason why I oppose this amendment is because factories which are presently around take sugarcane from farmers, and the sugarcane is a cash crop, Mr. I mean, is not a warehousable. Sugar is not a warehousable item, Mr. Chairman. Mr. Chairman, when they take sugarcane from farmers, they mill it and sell it immediately, and they don't pay farmers, Mr. Chairman. Therefore, farmers should be free to sell their cane to those factories which have cash and can pay. And there is always an arrangement between the sugar factories that if a farmer has loan from any particular sugar factory and he delivers in a different factory which is in a different zone, normally that factory which is in a different zone who has purchased sugar from this farmer will deduct the loan and pay that particular factory who is owed money. So there is no risk of farmers avoiding to deliver sugarcane where they have taken loan. The loan will be repaid anyway, Mr. Chairman. So I think farmers should not be oppressed. Me, I'm a sugarcane farmer, Mr. Chairman, and I have a factory like Moroni who has not paid me for more than 1 year. And when the other factories come to take my cane, where I have spent money, I took loan to develop it, they don't want me to deliver cane to those factories because they say it is poaching. And Mr. Speaker, I continue suffering and I have loans which I have also to pay as a farmer. And when you ask them why they are not paying you and they already took your cane, milled it, and sold it, where do they take money? Do they use farmers' money as their working capital, Mr. Chairman? I totally oppose this over-regulation of farmers.
Thank you. So, Honorable Senators, I put the question that Clause 19 be amended as proposed. Division at the end.
Clauses
Senator
20.
Kisang, you wanted to speak on this?
Yes, I even put intervention, Chair. Chair, I wanted to make a comment and say, I don't know if the farmers actually, during public participation, this thing was agreed or accepted, because this is retrogressive, Chair. Because the farmers should be free to sell their cane where they wish. Otherwise, a miller might take your cane and then they don't pay you. What happens? So this is, I think we need to oppose this particular amendment, Chair.
Yes, comment.
Mr. Speaker, I don't know whether to support the idea of the youth leader or to oppose it, because I'd like to beseech him to consider investors who come in and they help farmers with inputs. And then when it comes to an issue of output, then all of a sudden, that farmer now decides to sell that sugar to another miller. How will the miller recover their inputs? So, Mr. Speaker, I think what we need to do to safeguard both the farmer and the input is to further amend that amendment which is being brought, and I wish the sponsor would have been listening to it because it would help him, is that you put a caveat where the farmer does not have a contractual agreement with the miller, you know, then in that case, they are free to sell. Then there is no zoning. But where there is a contractual agreement, we have got to protect contracts. So I think we need to amend that section. So that will take care of the youth leader observations or reservations on that. And then it will also take care of the investor's interest. Because I've seen it in Narok County, where the Transmara Sugar Company has invested in the input. And then when it comes to harvesting cane, maybe sometimes there's a challenge, and maybe Transmara is not able to take all the cane at a go. Then you'll find that farmers are going to sell. So there are different things, mitigating factors that we can, you know, sort of like put in the bill, such that if the cane is ready to be harvested, and there is a contractual agreement, then with the consent of the milling company, the farmer can now sell that cane to another company. I think that will be a much sober way that will be able to resolve this issue. Thank you.
This clause has elicited a lot of interest. Senator Wakoli David.
Asante Mheshimiwa Spika. Katika kifungu cha 19A kuna maelezo bayana kwamba halmashauri hii itaweza kuwapa kibali wakulima wa miwa iwapo wataelekeza ama wataeleza kwa mapana na marefu kwamba hawana mkataba wowote na kiwanda chochote katika eneo lao, watapewa ruhusa kuendeleza na mkataba ambao uko katika eneo lingine. Vile vile, jinsi Mheshimiwa Senator wa Narok amesema, iwapo hauna deni na kiwanda ama kongamano la wakulima, vile vile utaweza kupewa nafasi, na vile vile hakuna stakabadhi yoyote inayoonyesha kwamba una mkataba wowote. Na zaidi ya hapo, Mheshimiwa Spika, 19B inaeleza bayana kwamba mkulima atapewa nafasi ya kupewa ruhusa na halmashauri hii iwapo kandarasi yake imekeukwa na msagaji wa sukari, hivi kwamba halmashauri itapeana mkulima ruhusa kuuza miwa yake kwingine. Vile vile mkulima ama halmashauri itathibitisha kwamba kiwango ama miwa inayopatikana katika eneo hilo imezidi kiwango cha msagaji wa miwa kudhibiti. Hivi wakulima watapewa nafasi ya kuuza miwa yao kiwanda kingine katika eneo lingine. Na mwisho ni kusema kwamba kiwanda ambacho anataraji kupeana miwa kiko katika eneo lingine na ako na mkataba. Sasa haya yote ataweza kuwafiki yale ambayo Mheshimiwa Oburu alikuwa anaangazia, ili kwamba mkulima asifinywe, na vile vile mikataba kati ya mkulima na kiwanda, kiwanda na mkulima, ama kiwanda na kingine, kila mwekezaji afanye jinsi sheria inavyostahili. Asante mwenyekiti.
Senator Osusi.
Mr. Speaker, you know, earlier on I rose on a point of order to demand that whenever the mover moves these amendments, justification of the same is very important so that members can follow up and so that any ambiguities can be handled. Mr. Speaker, if I look at this amendment proposed, there is ambiguity in it because a similar amendment is on new clause 19. So I think we must make a decision on which one to adopt. Is it the new clause or this particular amendment? At the same time, Mr. Speaker, the clause 19 talks about under D, talks about deleting the heading appearing immediately after subclause 3. Mr. Speaker, that heading talks about part 3 of the bill, which is licensing and regulation. I mean, it's jumbled up because this particular clause 19 is talking about a miller and grower and whether they have an agreement or not. I'm wondering why deletion of a heading comes in here. And the next thing is what happens to all those provisions under that heading. So we need to look at clause 19 here. At the same time, we compare what has been proposed under new clause 19, so that we don't end up having two clauses that are talking about the same thing. That is not proper lawmaking, Mr. Speaker.
Senator, also the clause, the ending is on clause 17, which was prosecuted by Senator Omatinga. Clause 17, not 19.
No. Then there is a mistake, because under clause 19 is talking about deleting a heading immediately after subclause 3. Subclause 3 immediately down there is talking about licensing and registration.
Senator Sosi, and this clause, the heading part 2, licensing and registration, has been moved from 19 to 17, which the chair, Senator Matinga, representing, has already amended.
Okay, what about the conflict between this clause 19 and the new clause 19A? It's talking about the same thing.
It's been deleted. Yeah, we'll get there, don't mind. We'll get to there. The 19. Let me put the question. So, Honorable Senators, I put the question that clause 19 be amended as proposed. The version are there.
Clause 20, 21, 22, 23, 24, 25, 26, 27, and 28.
I propose the question that clauses 20, 21, 22, 23, 24, 25, 26, 27, and 28 be part of the bill. I put the question that clauses 20, 21, 22, 23, 24, 25, 26, 27, and 28 be part of the bill. Division at the end.
Clause 29.
I propose the question that clause 29 be part of the bill. Chairperson.
I propose that the clause 29 of the bill be amended as A in subclause 1 by deleting the paragraph D and substituting therefore the following new paragraph. D. One person with knowledge of experience in the operation of sugar industry nominated by the Council of the County Governors. 2. Deleting the words nominated by universities appearing immediately after the words one person in the paragraph E and substituting therefore words representing the universities nominated by the Commission on University Education. B. By inserting the following new subclause immediately after subclause 1 and 1A, the Cabinet Secretary shall appoint the members under subsection 1A, B, C, D, and E by notice in the Gazette.
Can you, the chair, any time you do any amendment, you give the rationale,
okay,
so that we can, members can be able to understand you better.
The rationale behind this amendment, Chair, is that the inclusion of the county government, because the agriculture being a devolved function, it was important to ensure that the Council of Governors do take part in the nomination of the board and the people who will run the board. Secondly, by changing and substituting representing the universities nominated by the Commission on University to change from universities to Commission on University Education ensures that it is also inclusive, and therefore it does not claw back on the duties and the roles of the county government, because this involves agriculture, and agriculture is a devolved function. Thank you, Chair.
Thank you. I propose the question that clause 29 be amended as proposed. Senator Chalge.
Mr. Speaker, while I agree with this amendment, is that under this bill we are trying to establish Kenya Sugar Research Institute, and I think universities are our hub of our research. Although it has been a challenge since they don't have proper funding, but with Kenya Sugar levy fund that will be levied, it will allow extensive research in the type of breed that we can be able to plant differently across Western and Rift Valley part of this country. So, Speaker, number 2 is because agriculture, as Chair has said, is devolved. Number 3, and finally, is on the specific of person with a background. When the Council of Governors will be nominating, is somebody with a background of understanding of sugar, how sugar industry operates from the way it is planted, harvested, milled, and also in the marketing of sugar. So I think, Mr. Speaker, now that Kenya Sugar Directorate is with AFA, Agricultural Food Authority, it will now give opportunity for farmers, especially in provision of extension services and research and the growth and development of sugar industry in the country. I thank you, Mr. Speaker, and I support.
Senator David Wakoli.
Thank you, Speaker, Chairman. I want to reiterate what Senator Wamatinga has raised. The representative of the Council of Governors with a background in the industry of sugar ensures that the aspects that are devolved in this industry are well catered for. Remember, in the bill, we have inspectors, we have seedling preparation and dissemination, we have the pricing committee in this exercise, we have the cess that counties will receive, and therefore the person representing the counties must be able to understand the various regions that grow sugarcane and the dire challenges they go through. And therefore, they have no reason not to give as a qualified person to sit in the board and ensure that the Council of Governors and Agriculture, as be devolved, actually gets a fair presentation in the board. Thank you, Chair.
I put the question that clause 29 be amended as proposed, division at the end.
Clauses 30, 31, 32, 33, 34, 35, 36, and 37.
I propose the question that clauses 30, 31, 32, 33, 34, 35, 36, and 37 be part of the bill. I put the question that clauses 30, 31, 32, 33, 34, 35, 36, and 37 be part of the bill, division at the end.
Clause 38, there are 3 amendments. Clause 38.
I propose the question that clause 38 be part of the bill. We have 2 amendments, 3 amendments actually. We start with the chairperson.
I propose that clause 38, 6 be amended in paragraph A by inserting the words allocated to the Kenya Sugar Research and Training Institute after the words research and training, and B, paragraph and D, by deleting the words that words shall be managed by Kenya Rural Roads Authority of the catchment area, appearing immediately after the words development and maintenance, and substituting therefore the words of county roads and shall be allocated to county governments as a conditional grant on a pro rata basis. Chair, the rationale behind this was that the sugar growing zone cuts across counties. There are roads share that run inter-county, and therefore saying that it will be put on pro rata basis and managed by the Rural Roads Authority may be a disadvantage to some counties. Again, Chair, during the public participation, the issue of levies being raised and roads not being maintained was raised by various observants, and therefore it is important that that is operationalized by ensuring that it is managed differently in a way that those who pay the levy also get their roads maintained properly. Thank you, Chair.
Senator Olekina, I understand you have the amendments by Senator Sifuna.
Yes, I do.
Yes.
Mr. Chairman, I'd like to move an amendment on behalf of Senator Edwin Sifuna that clause 38 of the bill be amended by inserting the following new subclause immediately after subclause 1. The provision of subsection 1 shall not apply to imported industrial sugar. Mr. Chairman, the importance of this amendment is because the levy which was being imposed, this country does not produce enough sugar, and if you apply the levy of 4%, it makes it very difficult, such that all the sugar which is now being produced here will become industrial sugar. That's why, in the wisdom of Senator Sifuna, he thought that that should not apply to, the 4% should not apply to the imported sugar for the industrial purposes. I thank you, Mr. Chairman.
Senator Ososi, I understand his amendment is exactly similar to what Senator Sifuna has proposed. Therefore, we drop that amendment. Let's proceed. I propose the question that clause 38 be amended as proposed by the chair and both Senator Olekina. I put the question. You want to say something on this amendment? Okay.
Mr. Speaker, I support the amendment by clause number 38 by the committee allocated. Of course, the Kenya Research Institute is very critical. I had said that in cane development and in the sugar industry, from the time it is grown, the type of breed and many others. Number two, Mr. Speaker, I agree that this become conditional grant. Mr. Speaker, from some of us where we come, we normally have sales of tea and sales of sugar. Mr. Speaker, you are aware when they're transporting sugar, it always destroys roads, especially feeder roads within those areas where sugar is being taken, Mr. Speaker. And when you visit those areas, the factories or the milling, Mr. Speaker, normally pay cess. So I agree that this county road shall be allocated to county government as conditional grant, which will ensure the cess money that is paid through sugar cane delivery by the milling is cess money that should maintain roads within that area where sugar is being picked. Because, Mr. Speaker, when you visit like Chemelil, Chemase, you visit Chepterwai ward, Mr. Speaker, you visit Sopa Songo ward in Tindre sub-county, Aldai sub-county, Masab sub-county, and Kabiet, most of the roads that are being used to transport sugarcane, Mr. Speaker, will tell you they are in poor and pathetic conditions. And farmers normally complain that they are paid cess. So what I agree that debt has ring-fenced, Mr. Speaker. This thing, we cannot be managed by KERA. I know members of National Assembly wanted to be mischievous, Mr. Speaker, by giving, with all due respect, I know you are a former member of Law House. They wanted to use carer, and that is how, Mr. Speaker, they wanted to take normally the percentage. Mr. Speaker, and you have to appreciate carers continue to be inept in their duty, even with the current floods. Most of the roads are under care, Mr. Speaker, and Kenyans cannot access their homes because of poor drainage. So we cannot be giving carer more jobs when they have failed in what they are supposed to be doing. But let us give these sets money, sets to ring fence to the county governments for maintenance. Because, Mr. Speaker, in conclusion, most of these roads, Mr. Speaker, to be honest, are feeder roads. These are roads that are being picked from the farm to the factory, and most of them are feeder roads, Mr. Speaker. So I agree, let us ring fence it, let us make it conditional grants. Kenya carer does not have capacity. Carer continues to be ineffective even in maintenance of their own roads, Mr. Speaker. And I thank you and I support and submit.
Olekinda, you moved the amendment, so no, it was the same clause that 8. So I put the question. You want to make a comment on this clause that 8?
Yeah.
On the amendment?
Yes. Mr. Chairman, my comment is that I support the amendment because, Mr. Chairman, we used to have private factories. Private factories were maintaining roads in the sugar areas in those where you had private factories were perfectly maintained. And when these things went to the states, the roads went haywire. They were completely destroyed, Mr. Chairman. And now it appears our brothers in the lower house wanted to control this through carer, so that this thing remains as it is. And as it is now, those roads are in very, very poor state, Mr. Chairman. So maybe this says going to the counties as a conditional grant will help improve the road network there. But personally, Mr. Chairman, I would have preferred the privatization of these factories. They really maintain the roads. The roads used to be good. In fact, in Miwani, we used to even have railways within the sugar area transporting sugarcane, therefore not destroying the roads. Yeah, you can inform me, Mr.
Mr. Speaker, just I wanted to inform my brother, senior youth leader in the House, that the issue of privatization of sugarcane sector is ongoing, but that matter is still in court. And I agree with him, if we succeed with privatization, I think that is the direction we will take with the roads. Just like even, and I would want to see that proposal, Mr. Speaker, sir, through senior youth leader Oburu Odinga and the chairman of Odinga family, that we also bring it in the tea sector, where when the roads that are maintained by tea sector, it becomes accessible, especially through CES. That is what the information I wanted to add.
So, okay, I therefore put the question that clause that 8 be amended as proposed, the version at the end.
Clauses 39, 40, 41, and 42.
I propose the question that clauses 39, 40, 41, and 42 be part of the bill. I put the question that clauses 39, 40, 41, and 42 be part of the bill, division at the end.
Clause 43.
I propose the question that clause 43 be part of the bill. Chairperson?
I propose that the clause 43 be amended in subclause 2 by inserting the words "and the Senate" immediately after the words "the National Assembly." Mr. Speaker, Mr. Chairman, the rationale behind this is that when you talk about the Parliament, you talk about both the Senate and the National Assembly, and agriculture being a devolved function, the role of the Senate cannot be overlooked.
I propose the question that clause 43 be amended as proposed. I put the question that clause 43 be amended as proposed, division at the end.
Clauses 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57, and 58.
I propose the question that clauses 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57, and 58 be part of the bill. I put the question that clauses 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57, and 58 be part of the bill, division at the end.
Clause 59.
I propose the question that clause 59 be part of the bill. Chairperson.
Chair, I propose that the bill be amended by deleting clause 59. The rationale behind this, Mr. Chair, is that the farmers will be responsible for planning their own affairs. Therefore, there is no point of having the Growers Association.
I propose the question that clause 59 be amended as proposed. I propose the question that clause 59 be deleted. You see, there are requests here, but I don't know for which amendment. I put the question that clause 59 be deleted. Division at the end. But there are no requests. Yes, Senator Kajwang.
Mr. Speaker, clause 59 that has been proposed to be deleted talks about representation of growers in a private milling company. And, Mr. Speaker, I'm extremely hesitant to support an amendment that curtails the representation of the key players in the sector, who are the growers. And I would have loved that the senator who has moved the amendment could have given a deeper rationale for this, because I'm sure clause 59 with 3 subclauses must have been subjected to rigorous public participation. And we might be accused as the House that then allowed the private milling companies to operate without considering the voices of the growers, who are very integral to this particular industry. And so, in as much as when it comes to the vote, I'll probably ask the senator to give me greater rationale, but it would have been very good for it to go on record, the thinking and the public push, the public, agitation that has informed his decision to convince the Senate to drop representatives of growers in private milling companies. And when I say that, I'm looking at an example of Sukari Industries, which is one private miller in Homa Bay County. If there was that hope that the growers will have a representation on their board of directors, Mr. Speaker, I'll find it very difficult to go back to the residents of Ndiwa and tell them that the Senate decided that the private miller will run his operations unfettered, the rise of this world will run the operations unfettered without any representation from the local community. Because I see this as the entry point, the voice of the local community, the local players in that private milling company. Mr. Speaker, I know the mover might not be allowed to speak twice to the question, but let it go on record why he thinks that we should support that deletion.
Senator Ososi.
Mr. Speaker, when we were doing second reading, I am among the people who opposed this provision. clause number 59. And I want to differ with my good friend Senator Kajwang in the sense that when we allow farmers to sit on the board of a private miller or a private company, that goes against the dictates of our Company Act, and that is likely to discourage private investors in investing into our country. And the second part of that clause, Mr. Speaker, talks about a representative of a farmers organization, which basically means the farmers will sit and do an election and choose someone who will sit in the board of that private company. That in itself creates a risk situation for a private investor because of the political process of choosing that particular representative among the growers. So I think this clause 59 is retrogressive, and I think we should delete it. In any case, the bill has a regulatory mechanism through the board of managing challenges or interests of the farmers. So I support the deletion, and I want to differ with my good friend Moses on this.
Yes, it's Majority Leader.
I don't see why there should be a fight about this, and I agree with the position by Senator Osotsi for this simple reason. Sometimes we make laws which, unfortunately, are in contradiction to already established laws. There's already set out law on how you become a board member in a company, especially a private-owned company. The Companies Act is quite clear about it. That's why how you become a board member. There is no way you can do a subsidiary legislation and purely just for one group of company. In fact, this you don't need even a good lawyer. Even an intern will strike out this legislation, Senator Kajwang, on the simple, on even grounds of discrimination alone. Because somebody else will ask, why not then Mbita millers for maize farmers? Then the farmer said, we have to be in this company because we take maize there. Then fish farmers also say, because there's an agro-processing company, that place we went, what was that farm? The guys that do very huge victory fish farmers. Then the farmers will say, because we deliver also, we deliver our fish to this company, we need to be there. So it's in violation of already existing laws in my assessment on how you become a board of director in an institution. And to single out one entity alone and say, only in sugar farming will you have, then you'll be asked, what about maize farmers? What about tea farmers? What about dairy, fish? All these are the private that deal with the public. So I think I agree with the wisdom of the committee.
Senator Wakoli.
Thank you. I want to rubber stamp what Majority Leader said, and the resolution of the committee to delete that particular section was out of a rigorous public participation exercise that we did across the country. We met stakeholders in the industry, owners of companies, and they expressed their reservations of their hard-earned investments being threatened by external imposed representatives by this law. And we believe as a country we need to create a good working environment for investors in the industry, and therefore we had no other option but to do what is legally correct by deleting that particular section. So as a member of the committee, we stand with the deletion. Thank you, Chair.
I now put the question that clause 59 be deleted. The version at the end.
Clause 60.
I propose the question that clause 60 be part of the bill. Chairperson.
I propose that clause 60 of the bill be amended in subclause 2 by inserting the following new paragraph immediately after paragraph K. KA, the procedure of election for farmers and millers represented to the board and the placing committee. The rationale behind this share is that the regulations governing the appointment of the board members is regulated in the bill, and therefore it needs to be put in such a way that the operationalization will be without any hiccups. Thank you.
I propose the question that clause 60 be amended as proposed. Stand on this particular clause 60. Proceed.
Mr. Speaker, while I support procedure of election and Miller's representative to the board and the pricing committee, two things I want to say. You know, under this bill, Mr. Speaker, we are going to have directors Kenya Sugar Board that will oversee the running of sugar industry within that. And when you look at the Company Act, that provision has been provided for, Mr. Speaker. And even on the first schedule, where the regions will be able to elect their representatives, it becomes easy to run. So, Speaker, and also Miller's representative to the board of these farmers and millers are conjoined twins. They are like CMS twins. They need each other. They must have what you call symbiotic relationship, because you cannot have a miller without a farmer and have a farmer without a miller. So there is that CMS or symbiotic relationship that within the industry, such Speaker. Therefore, I agree that they must be there so that their interests are protected, especially with now where we are removing the management of sugar from Agriculture Food Authority, AFA. Finally, Chair, on the pricing committee, as you are aware, we are having crisis at sugarcane farmers. A few months ago, the tonnage was around 60-50. Now it has fallen by half, and there was hue and cry by sugarcane farmers with that arbitrary lowering of the ton or per ton of selling of sugarcane, Mr. Speaker, by almost half. So sugar pricing committee is very critical, because when you look at the bill proposed as is proposed, will ensure, Mr. Speaker, the interest of farmers are well catered for, not only on pricing, even on when like, for example, this season, Mr. Speaker, thanks to this excellence, the President, by provision of subsidized fertilizer, Mr. Speaker, it has made it easy for farmers to produce more on tonnage. And therefore, Mr. Speaker, it goes a long way to ensure that this representative of pricing committee and the board becomes issue, Mr. Speaker. I thank you.
You know, Senator Cherege, you are taking advantage to go to the content of the bill as we are in second reading. You just make a comment on the amendment. But you must hide that. Because I thought you are one of the seasoned registrators in the Senate. The newcomers like Senator Mudigi are doing so well. Yeah, you see, he's not just talking for the sake. Mudigi is now a veteran. Dr. Mudigi, sorry, Dr. Mudigi. But you are not requesting Senator Oburu. You are using the own system.
Mr. Chairman, I just want to add my voice to this inclusion of farmers and millers together in the board, because, Mr. Chairman, when farmers are involved in pricing, at least their interest is protected and taken care of, because sometimes when you have only millers and the government representatives sitting in the board, they exploit farmers by, for instance, in that zoning, there is zoning of transportation. There is zone A, zone B, zone C, and you find that the farmers lose tremendously on the pricing of transportation. The transport charges are very high for the farmers if they don't take part in the pricing policies, Mr. Chairman. So working together of farmers and millers and the government, representatives from other bodies in the board is very, very important, and I just want to add my voice to that, the importance of having farmers and millers together. Thank you, Mr. Chairman.
Okay, thank you. I put the question that clause 60 be amended as proposed, division at the end.
Clauses 61, 62, 63, 64, and 65.
I propose the question that clauses 61, 62, 63, 64, and 65 be part of the bill. I put the question that clauses 61, 62, 63, 64, and 65 be part of the bill, revision at the end.
New clause 19A.
Mover.
I propose that
Chair, approves the guidance. Okay, proceed.
Thank you, Chair. I move now that the new clause 19A be read for the second time.
What's your rationale?
Chair, we do notice that there are regions, that the zones that have been, which are in the sugar growing sector, but they have the disadvantage of not having enough factories or up millers, and therefore they may be disadvantaged if we do not introduce this new clause, so that they do not suffer from the restriction that may have in other zones that have several millers in the area.
I propose the question that new clause 19A be now read a second time. Senator Buru, you must request to speak. This is the third time. You must use your card.
Mr. Chairman, I spoke on this issue of actually over-restricting farmers. Mr. Chairman, you know, introducing regulations which now introduces the board to allow the farmer to sell to the other, to sell to the other zone. Mr. Chairman, is actually introducing corruption, because this is another hurdle. Already the millers themselves have agreed that if a farmer delivers cane in a zone which is not theirs, and it has a loan with a factory in another zone, the loan is deducted and paid to that particular factory. So what is this board now which is being introduced here, this bureaucracy that the farmer has to apply to the board? The farmer has to apply to the board to give them permission to deliver cane in another zone because of A, B, C, D, too many reasons being given. Mr. Chairman, I think this is this is oppression of the farmers, and farmers are suffering already from some of these regulations. Mr. Chairman, I totally oppose this kind of amendments.
Senator Mudigi.
Bwana Spika, naweza kuambia seneta mwenzangu, wakati tulikuwa natengeneza hii mjadala, ni vizuri tuliona, kwa sababu siku hizi ni wakati wa demokrasia, ni afadhali mtu awe akiuza vitu zake ama pahali anaona, kwa sababu unaweza kumwambia apeleke upande aona haifai na upande nyingine iko na bei ya juu, kwa hivyo hatukuona ikiwa mbaya, kwa hivyo tuliona ni vizuri iwe namna hiyo. Bwana Spika.
Majority Rinda.
I want to plead with my neighbor, Senator Buru, to understand, because this amendment, actually, in my opinion, helps the farmer achieve what you're saying. It is a previous amendment of clause 19 that closes all farmers in one region without room for exit whatsoever. And farmers, for us that are, for example, in the central region, that is Kericho, Kisumu, and South Nandi, we have only 2 private factories. If you close those farmers into that region alone without providing any exception for them, yet there is clear evidence that even with the presence of those 2 millers, there is still an oversupply of cane. Therefore, to marry the situation where you have regions in the country where there is an overabundance of factories and therefore farmers have got sufficient choice of where to take their cane, and us who come in areas where we still have the unique challenges of not having sufficient factories, it was important that you provide this provision so that if for one reason or the other farmers want to supply beyond the areas where they have been put, as is the case for those that are opposed. You know that there was a big debate when this committee went to Chemelil to listen to farmers from Kisumu, Kericho, and Nandi. There are those who wanted zoning for reasons best known to them. There are those of us that were opposed to zoning. And therefore, in their wisdom, the committee listened to those that were opposed to this issue of being zoned in an area where there isn't sufficient factory to take their cane, and requested that this provision be provided. So that if you make a request and say, we have received support from a particular factory outside our zone because those that are there are not sufficient to take our cane, then it was important to provide this exception. And I think, to me, it's a fair proposal, given the unique situation that those in the central region find themselves in. Another region that will find themselves with this situation, and I wish Senator Ledama was here, are those that come from Transmara or Narok? Yeah, the southern region. Those from Migori, Homa Bay, Kisii, and Narok counties, for example. In Narok, the only active factory, private one, is Transmara. If you restrict them to that particular region alone without providing any exception, what happens if there is a breakdown, for example, and it takes a longer period to repair? You must, therefore it was important to make this provision, and I want to plead with you to agree with the wisdom of the committee. I thank you, Chair.
Yes, requested.
Senator, okay, Senator Oburu.
Mr. Chairman, I don't support restriction. Personally, I don't support restriction. That is why I don't really support this idea of bringing in the board to give permission. There should be free. Farmers should be free to sell their cane where there is good pricing, where there is good payment, where there is good treatment in terms of business. There are people who even give loans to farmers to pay school fees. There are others who don't care. You have a child sitting there and your cane is lying with the sugarcane factories. They don't give you money. But there's factories who even pay you when your cane is still in the farm. They come and they assess your ability to repay the whatever loan. They give you loan to even pay school fees for your children. So if you have such kind of treatment, even if the other factory had given you loan and they are not paying you money, you should be free to sell your cane there, and there should be an arrangement where they recover their loan. If they gave me money to develop cane and they don't want to be good to me, they are not paying me, they tie me to some draconian agreement which make me suffer. Mr. Chairman.
Senator Mandago.
Thank you very much, Chairman. I am also uncomfortable with that clause 2A. You know, the board chair will be sitting in Nairobi. Farmers will have difficulty in accessing the boards to give the approval. I don't know the wording that can be amended, whereas it is important to make sure that there is a bit of control,
But for them to apply to the board, that will take ages, and farmers will extremely suffer. With the explanations that have been given, Chair, on the zoning, I really don't have a problem. But this restriction, particularly a cane farmer, large-scale cane farmer, who may not have loans, and they still have to seek permission. Why do they have to seek permission if I have no loan with anybody? Why can't I take my cane anywhere I want? I submit.
Senator Wakoli David.
Madam, I want members to ventilate. I'll bounce back.
My chair, where's the butter? I'm using the screen. So stop calling chair. No, you quiet, keep quiet. Okay. What did you say, Senator Wakoli? Oh, okay. Senator,
it's not that I'm not interested. I am considerate of members, especially proponents of the bill, to espouse
Senator,
what is in detail. Thank you, Chair.
Senator Chelgei.
Mr. Speaker, I invite members to look, especially senior youth leader Senator Oburu, to look at the intent and principle and the spirit of this introduction. Mr. Speaker, why? Because, one, you remember AFA issued a letter closing some factories in central region. That is Kisumu, Kericho, Nandi South. And your cane is ready. Mr. Speaker, every game has rules and it has a referee. The reason Kenya Sugar Board is being removed from as Sugar Directorate from AFA, Agricultural Food Security, Agricultural Food Authority, is to give opportunity Kenya Sugar Board to become regulatory. The Kenya Sugar Board is a regulatory body. Just the way, Mr. Speaker, when I'm selling my milk to Kisumu, I must get a license from Kenya Dairy Board to take my milk from Nandi to Kakamega or Kisumu. This creation of this exemption, Mr. Speaker, is that, for example, Chemase, Mr. Speaker, a day, Chemase, what in a day we produce 1,800 metric tons of cane. Let's assume the 7 factories, only 2 are functional, do not have sufficient capacity. Then the exemption can be provided for me to take that sugar cane to Vihiga or Kakamega, which is in another zone, Mr. Speaker. So this exemption is within the power of Kenya Sugar Board, which I think, Mr. Speaker, and I want to correct Ms. Noma, it doesn't mean that Kenya Sugar Board will only sit. They will have offices, just like the way Kenya Dairy Board has offices, other sectors have offices, Mr. Speaker. So this one is to ensure that when there is excess, Mr. Speaker. And then finally, I have heard something very dangerous from Senator Oburu, Senator Oburu. But saying that, Mr. Speaker, saying that you should not be tied with draconian agreement. But it is you, the farmer, and the miller who went to an agreement. If we allow that agreement to be broken, Mr. Speaker, it means we will be allowing cane poaching and cane hawking. Because if I'm doing cane development as a factory, Mr. Speaker, if I'm doing a cane development as a factory, then somebody somewhere like Oburu factory wants to come and buy without following the agreement, then it will bring chaos in the industry, Mr. Speaker. I submit.
Senator Orekino, kindly just make a comment, don't debate. Just a comment on the amendment.
Chairman, I think, you know, this is actually a very important debate. But I can listen to both Senator Cheruyot and also Senator Oburu. And I think Senator Oburu has a point. One point that he has is that what does a farmer do when the company that you have a contract with refuses to pay you money and you have a loan that you're supposed to pay? So I think we need to be able to discuss this, Majority Leader, to find a way to make sure that that farmer is not tied to that miller if that miller doesn't pay them. So I think we need to further amend this And that's why I'm thinking you shouldn't be in a rush to pass this. We take care of the interests of the farmers that Senator Oburu is representing, because Senator Oburu, when we were consulting, he told me that he has a relative who has not been paid 2 million shillings, that has taken a loan, and when that relative attempts to sell sugar to another milling company, Muaroni Sugar comes and say, it is poaching, we will not allow. And they have not paid him for 2 years, for over 2 million shillings. So I think we need to have a balance, where we need, but this board, the problem that I have with boards, Mr. Chairman, the problem that I have with board, I agree with Senator Oburu 100%, that we are creating a lot of bureaucracies. All we need to do is to be able to protect these farmers and say that if there is this contract, that contract must be respected by both parties. Because there is no point as to why the miller do not respect the contract by not paying the farmer for 2 years. If it says when you collect my cane, pay me, you know, you see, let me just finish. Let me finish my argument. No, but that is the issue. That is the issue that Senator Oburu has an issue with having this board. Okay, you know, I'm happy to be informed because I want to have a middle ground. Because I sat down there, Mr. Chairman. I'm happy to be involved.
You want to be informed.
This is Senator Ledama. I think you're conflating issues. What you're describing is a situation prevailing where a farmer has delivered cane to a certain miller and they haven't been paid. And you're arguing that we need to provide mechanisms to ensure that they recover whatever they have delivered. That's a completely separate issue from the debate that we are having with Senator Oburu. Senator Oburu holds the position that there should be no exemption or restriction in the game, that it should be free and open. Unfortunately, and this played out here on Tuesday, I don't know if Senator Ambo was here, where we had farmers even from one region, the central region. We had farmers from Nandi, Uasin Gishu, and Kericho who appeared before the committee. The way it had previously been drafted in the law, where there was no this clause on exemption, the farmers were up in arms because they are saying, you are lumping us all up in one region without providing room for us to do now what you are asking that it be provided for them to deliver wherever they feel like they want to deliver. And that is why we have provided this exemption with conditions saying, number one, you demonstrate that you had a pre-existing agreement with a miller and say, despite the fact that I am in the central zone, already, I have an agreement with another miller. Please exempt me from that. Or 2B, the grower is not indebted to any miller or outgrower institution within the sugar zone, meaning that you don't owe anybody any money. You're not running away from anybody. And C, finally, you don't have a supply agreement between you and any of the miller within that particular region. So I think, Senator Oburu, this is a perfect middle ground, given the fact that in the absence of this law, of this Part 19A, you are left only with Clause 19 as it is, which has put farmers into zones with no exit clause for them. Yet there will be farmers who, because of what you have described, they feel a certain miller who is not within their zone treats them better, and they want to do business with that miller. So I thought that's a better middle ground. The only point that has been raised, Chair, which I want to, maybe the committee, we need to reflect. You know, an average farmer in Kipsitet or whichever part, how to access the board is something that perhaps the committee needs to guide us on how that will be done. Because you don't want to leave a peasant farmer who has an acre or 2 or 5 acres of cane at the expense of a body that sits here in Nairobi. So probably there needs to be better drafting of that particular part. And it was until Senator Mandago said it that I actually thought about it and said, maybe either the chair needs to guide or we need to reflect, because the people in the house here are all representatives of sugarcane farmers. So we need, maybe as we go along with this discussion, Chair, after members have spoken, we need to sit down and agree on a better draft to this exemption other than leaving an interaction between farmers and the board. Senator Kajwang says he has a proposal.
At this juncture, listen. The chair has handled the discussions from both sides. So I want to give you an opportunity because maybe.
But Chair, I was being informed. I was being informed, Chair.
Maybe in a minute then Kajwang.
Yeah, just conclude.
Yeah. No, but I was being informed. I mean.
Order, senators. Order.
Chair, in fact, what Senator Cheruiyot is saying, Chairman, what Senator Cheruiyot is saying is exactly what I was saying. That the problem that Senator Oburu is having with this restriction is the board. Secondly, Senator Oburu has a problem with people who don't pay. If you are restricted to that zone and that zone is not paying you, it's still the same problem. Okay? So that is why I said, by the way, I'm actually in agreement with you. From the onset, I've been in agreement with you. I was trying to persuade Senator Oburu, and now I'm in agreement with Senator Oburu. Senator Oburu has a problem with one, and I also have the same problem. And Senator Mandago has the same problem with this bureaucracy of creating a board. Okay? To be able to give those exemptions. So me, the problem that I have, and I agree with Senator Oburu on this one, let me tell you, I agree with him on this one, that now how do you expect a small farmer who has got 2 acres, to go to that board to seek approval to be able to go and sell cane somewhere else? Okay? So, can I finish? Because you have to allow me to finish, to conclude my point.
Just conclude.
I think the best way forward is this. Because it is good for us to agree, because we're all fighting for our farmers. I have a problem with my farmers in Narok being forced to sell their cane to another zone because maybe they have a problem with where they're selling, they're not being paid. Me, I have a problem with that. I have a problem with creating bureaucracies where you have a board that sits in Nairobi, that every farmer has got to come now and seek exemption, that they say, I don't owe any miller here, I want to go and sell, because it creates an avenue for corruption. So that's the problem that I have. So my proposition is as follows. I think the best thing is for the committee to relook at this issue and see how to redraft the powers of the board. Or if we are to do it, if we amend it here, it helps us. My problem, I have a problem with these bureaucracies of these boards. Me, I have a problem with that. Leave the farmer. I wish we could I don't even know why we are controlling this crop so much. Allow the farmers to grow the cane, sell it to wherever they want to sell. The problem is when...
Senator Kajwang, what is your proposal?
Mr. Speaker, we are probably losing the essence of this bill. And the essence of this bill, for those who have done systems programming, you have something called an entity relationship diagram. We are establishing zones, each zone with growers and millers. And we are saying we are restricting activities within those zones. But for the reasons that have been provided in the proposed clause 19A, particularly the second reason, the grower is not indebted to any miller or outgrower institution within the sugarcane zone. That grower cannot be compelled to supply cane within that zone. And I think I hear what Senator Cheruiyot is saying. It is the drafting here that could be problematic. And Mr. Chair, if we could get an opportunity to redraft this and exclude the mention of the board and say that a grower shall be exempted from the restrictions on supply of cane if the grower is not indebted to any miller or outgrower institution. And we drop clause 19A2, which then compels the grower to go to the board. I think that's where the problem is, that the board is an unnecessary bureaucracy. And in any case, Mr. Chair, we are saying that the Cabinet Secretary shall prescribe regulations for consideration. And we know that sometimes Cabinet Secretaries take forever to bring regulations to this House. I know under delegated authority, we have given the Cabinet Secretary 6 months to come up with regulations. But remember, this is an amendment that has not been carried over to the responsibilities of the Cabinet Secretary and a delegated authority. And
Thank
so,
you.
Mr. Chair, I agree that we remove this board so that if I've grown my cane using my money, my resources, my fertilizer, my seed, allow me to sell it wherever I want to
So,
sell it.
Chairperson of the committee, you have heard the sentiments from the members. So maybe if you are agreeable, you can be able to see how to navigate the wording of this clause. So I want to hear first from the chair.
Thank you very much, Chair. We are well guided. But I would also want to put it this way. We know that most of the times we effect laws by, like we operationalize laws by creating regulations. Chair, why we brought the board here in this particular bill, it's because you need to bring some sanity. We know that if we leave it to people or to farmers or to people just decide what they want to do, there would be abuse. Of course, the question that has been asked makes a lot of sense. How will peasant farmers access the board? Chair, I would want to put this, it is the regulations that will operationalize how they'll access the board without even necessarily having to capture it in the document. That is it. And I believe most laws are operationalized through regulations. I do understand that the concern of members that the ministry takes so long to bring about these regulations. It is our interest as a committee to ensure that the farmers in this country get their services and their income optimized by ensuring that the laws that are in place and the regulations do address the patent issues such that has been raised in this House. Chair, I submit.
Senator Wambua.
Finally, Chair, I get the floor. Two things, Chair. I think members, we need to appreciate where we are coming from. And I have sat in this committee, I've been engaged on this matter of sugar from the last session and even now. Someone may say, I don't produce sugar where I come from, but I'm a net consumer of sugar. Chair, we are coming from a situation where we have a monster called AFA. That pretends that it can regulate every crop, everything under the sun. And so what they do, they create directorates. Now, at the sugar, such an important sector in the economy is managed by a directorate under AFA. And I hear my brother, senior counsel here, asking, why do we want to expose farmers to a board? And this is my response to this. The board is a better evil, much better evil than AFA. Because the farmers are in the board. In AFA, they don't exist. In AFA is a directorate, it's a Nairobi-based thing. They make decisions here, and those decisions are implemented in the farms. That's point number one. Number two, Chair. Let us also be reminded that 3-4 years ago, there was a task force that was set up to look into this matter of the sugar sector. And that task force came up with recommendations that have found their way into this bill. The chair has not asked whether I want to be informed, but I don't know.
Senator Wambua, you know we are on a committee of the whole, so you don't need to do a lot of...
Chair, let me, when Senator Wambua informs, there's a problem. When other people inform, it's okay. Chair, what is the problem here?
Just a comment.
Yeah, I'm just making a comment. And I have not taken even half the time that people have taken to say a lot of things. What is the problem? So the last thing that I'm saying, Chair...
Just conclude.
Yeah, I'm concluding. I'm concluding, Chair.
And I'm happy that the chair of agriculture is listening to me, even if the chair is not listening to me.
This thing about growers and zoning, that task force, zoning actually is meant exclusively for purposes of voting, for electing board members. The decision as to where a grower will deliver their cane is a deal between the grower and the sugar factory. And there is nobody being forced and being told, because you are growing your sugar in Kericho, you must sell it here in Kericho. If a grower in Kericho thinks that they will make more money selling their cane in Kwale, then they sign a deal with the factory in Kwale and they sell their cane there. There's nobody who is being forced to sell their cane within the zone. The zoning thing was purely for purposes of voting and election of board members. I thank you, Chair.
Thank you. So, if you really understood what the chair said, is that we have an alternative in part 3, but still we are not closing this matter. For the purpose of making progress, we are not making determination now, we are not voting now, we can open this matter again. So let us proceed to the next clause.
So that the matter is finished.
Yeah.
Since you are not voting today, pardon? Since we are not voting on it, Senator Matinga.
So
No decision will have been made.
you see, no decision has been made now. So therefore, that is why, you know, the other alternative is to go all through to the division. Yeah. Because if a matter, we cannot resolve a matter of drafting now.
Let me tell you, Mr. Chair.
So that now we can go to 19B. Leader.
We are not coming to. Unaenda kwa 24 months. They are not coming to pick your.
So majority leader and your team, eh? Yeah, consulting behind so that we can make progress. Majority leader. So I put the question that the new clause 19 be now read a second time. Division at the end.
new clause 19B.
Mover. Now listen to the other one, Honorable Senators.
Chair, I now move that the new clause 19B.
Senator Chelagay, settle down first.
Chair, can I be heard in silence?
Yeah, sure.
Chair, I now move that the new clause 19B be read for the second time. Chair, the rationale behind this is that a miller may have a breakdown and not be able to pick the cane from the farmer. Therefore, it is important that we open up that in such a case, the farmer will have a choice of when the factory, such a factory has broken down, can be able to sell his cane, because some of these repairs can take a long time, and without necessarily disadvantaging the farmer, we want to create a situation whereby the millers can agree between themselves to take up the cane from farmers. Thank you, Chair.
I propose the question that new clause 19B be now read a second time. Senator Kajwang.
Yeah, Mr. Chairman, the essence of this bill, the DNA of this bill, which I will keep referring to, is that we establish zones and we define millers and growers within those zones. And I think that to argue against that essence is to argue against the bill in its entirety. Now, the clauses 19A and B are providing a window for exceptional circumstances. Clause 19B talks of intermiller agreements, but it assumes that those agreements can only exist within a zone. I believe, Mr. Chair, that there will be a situation where you will have interzone intermiller agreements, millers in different zones. And therefore, I want to urge the mover of this amendment that in the same manner, under clause 19A, you provided for a procedure where there can be consideration of agreements between, or where a grower can send his cane outside the zone. Mr. Chair, I want to urge the senator who has moved this amendment that let us also have a clause 19B2 that will address interzone miller agreements, so that if a miller in zone A, for whatever reason, finds it necessary to move cane or to have relationships with a miller in zone B, then there is a prescribed form for that kind of arrangement. Mr. Chair.
So Senator Kajwang, I want to rule that maybe at the rise of the House, you are the chair of the committee, the mover, Senator Wakori, the majority leader, and any other senator interested to look at 19A and 19B, to have that opportunity to do that today.
Yeah, thank you, Mr. Chair, because we cannot make it difficult for growers and make it easy for millers.
Yeah, I've heard the concern of the senators. So I think we have made some progress, Senator Majority Leader.
They are negotiating, eh?
Majority Leader, we have opened we have opened it up so that we will negotiate to discuss 19 and B.
Okay.
Yeah.
How far is it?
We are still a couple of clauses. We are still far behind. So
Endelea.
yes.
No, nimechoka sana. Nimekaa hapa kutoka tu. Honorable Senators, after my ruling, I want to put the question that the new clause 19B be now read a second time. Division at the end.
The first schedule.
Senator Chaligay.
You have your amendment.
Yes.
The first schedule. You withdraw.
How much more are you remaining?
Mr. Speaker, since, Mr. Speaker,
Proceed, Senator Chelgi.
Mr. Speaker, since a new schedule, I have seen there is an amendment of new schedule that has been introduced. Mr. Speaker, I request that the first schedule, Mr. Speaker or Madam Speaker, the first schedule, Madam Speaker, remain as is for only purposes of elections to representative of the farmers as per clause number 6B, where first schedule has only be used to elect directors to Kenya Sugar Board. Madam Speaker, my aspirations has been captured by introduction of new schedule that will create sugar zones of central region, that is Kisumu, Southern Nandi and Kericho counties, on upper western Bungoma, Kakamega, excluding Mumias areas, Trans Nzoia, Uasin Gishu and northern Nandi counties. Therefore, Madam Speaker, this introduction of new schedule has captured my aspiration, and with that in spirit, Madam Speaker, I request the first schedule remain as is, and I therefore withdraw that amendment because it has been captured in the new schedule. I thank you. No.
So the proposed amendment is therefore withdrawn. That's in the first schedule.
Yeah, the amendment to the first schedule I withdraw. It remains as is for elections of directors only. Yeah, there's a second schedule introduced by Wakoli. A new schedule.
Second and third schedules be part of the bill.
Now I will therefore put the question. I will now propose the question that the first schedule, the second schedule, and the third schedule be part of the bill. Division. I put the question that the first schedule, the second schedule, and the third schedule be part of the bill. Division at the end. Yes, Senator Kajwang. On the second schedule?
Yes.
You have a proposal?
Yes, you have a concern.
Okay. Proceed.
Madam Chair, first of all, when this bill came from the National Assembly, there was only one schedule, and that was a schedule that was to form the basis for election and for delivery of cane. Madam Chair, the initial printout of the order paper that proposed the second schedule, Homa Bay County, which is a sugar growing zone, was excluded. I have just looked at the supplementary order paper, and I can see now that Homa Bay has been put in the southern catchment area. But it would also be important, Madam Speaker, for the mover of this amendment to, or the inclusion of second schedule to explain to the House, if we are together for elections, it means that we have certain common and similar interests. Why then do you separate us?
Senator Kajwang, if I may render some assistance to the concern you're raising, it may be premature because your concern will be addressed by the chair of the committee in the new, when he's moving the new schedule. So the Homa Bay County, if left out previously, will be addressed by the chair in the new schedule.
I thought you had read out second schedule, because that's a second schedule.
It is in the new schedule.
Okay.
We will get there. Maybe you can comment if it doesn't meet what you want, the standard you want it to meet. So now, I repeat the proposal of the question that the first schedule, the second schedule, and the third schedule be part of the bill. Division at the end.
New schedule.
I call the chairperson, Senator Wamatinga, to proceed.
I now move that the new schedule, I propose that the new bill be amended by inserting the following new schedule immediately after the first schedule.
For clarity, are you moving the new schedule in an amended form?
Yes, Madam Chair, because it is differently composed than what we had proposed initially.
Can the Secretariat then circulate the new schedule so that Senator Kajwang can see whether his concerns have been addressed in the new schedule? So you'll get a copy just now, and you can confirm that you are comfortable with the proposed new schedule as amended. Senator Kajwang, you have the new schedule? Yes, you can proceed if you have any.
Madam Chair, this is usually a very important stage in lawmaking. And I'm a bit uncomfortable because, before this amendment was done, Homa Bay was missing. And if I was not in this house, or if someone was not going to point it out, perhaps Homa Bay would have missed out of the sugarcane zones, and that would have been a great tragedy. But my concern is, when this bill came from the National Assembly, we had one schedule, which was supposed to suffice for election and for delivery of cane. I have not heard the strong justification from the mover of the amendment, the member who proposes a new second schedule for sugarcane zones, because the problem is that it has disaggregated. For example, in the first schedule, you'll find that Kisumu is in the southern zone. Kisumu, Migori, Homa Bay, Kisii, and Narok. In the second schedule, you find that Kisumu has now moved to central. Kisumu is now with southern Nandi and Kericho counties. Madam Chair, this could be mischief, but I do not want to impute improper motives. I would just like the mover of the second schedule not just to leave it as amended, to be included in the amended form, but to justify and tell the House why the second schedule is significantly different from the first schedule. Because if you're going to use a unit for elections, then it follows that that electoral unit has similar interests and concerns, and that is a unit you also use for development of cane. This can bring about certain confusion. I don't see the member from Kisumu, but I would have been interested to find out whether the member of Kisumu is comfortable that for election purposes he is lumped up with Migori, Homa Bay, Kisii, but for cane development purposes is lumped up with southern Nandi and Kericho counties.
Chair, Agriculture, I think that concern is valid. You have a concern which is aligning to the concern raised by Senator. Okay, I will let you then ask the question. Then, Chair, you can prepare to respond to that. I think the concern is valid to justify why the schedules, the second schedule, why it's been adjusted.
Thank you, Madam Speaker, for the indulgence. When you look at the bill, clause 6.2b, clause 6b, the first schedule, Madam Speaker, is specifically used for elections of farmers representative from the 5 regions, Madam Speaker, for purposes of elections to Kenya Sugar Board. This second schedule, Madam Speaker, I come from Nandi County because he asked a very important question. In Nandi County, Madam Speaker, I don't have a miller or a sugar factory. I am only in Nandi South, I am only 18 kilometers from many factories that are in Kisumu. In Nandi North, Madam Speaker, the reason I want to work with Kakamega for cane development is because most of the factories, Madam Speaker, are in Kakamega. For example, Naitiri, Cabras, and one is Butali. When you come to Nandi South, Madam Speaker, we have Kibos, Moroni, Miwani, Soni, among others. So it is only 18 kilometers from where I am in Nandi South to deliver cane, and that is the main reason, Madam Speaker. And that is why this second schedule is very critical because it allows farmers convenience of cane development within, because for example, Nandi does not have even one sugar milling factory. But when you go to Kisumu, it has more than 7. So if you are to, for example, to put Nandi, Kericho, and Uasin Gishu, only Kericho has one sugar factory that might not be able to accommodate the capacity because that factory might only be crushing 1,200 metric tons. Chemelil Chemase, which is next to Kisumu, only 18 kilometers, produces 1,800 metric tons. And you have not added Sowin Sigawit, you have not added Kipkelion, you have not added Aldai, you have not added Masop, Tindret, Madam Speaker. So it will be overwhelmed. So the intention of this were for purposes of only cane development and delivery. But when it comes to elections, Madam Speaker, we remain with the first schedule to allow farmers to elect and also for regional balance. Yes, you can inform me through the speaker.
Now, you know, Senator Cherargei, you know business is not conducted like that. I'm in charge. So I'm the one to request him, to ask him whether he wants to be, to request you whether you want to be informed.
Can I be informed, Madam Speaker? By Senator,
You can
my
proceed,
chairman, my super
he has
chairman.
accepted.
Thank you, Madam Chair.
You know, he's my super chair.
And we work very well with Senator Cherargei, including and up to yesterday when we were looking at the books of Nandi County. I just wanted to inform Senator Cherargei about that saying, what is good for the goose is good for the gander. So if a unit is good for electoral purposes, why isn't it good for cane development purposes? That you want to redefine a different unit for election and a different unit for cane development. Is it that you fear that if you are lumped up with Kisumu for electoral purposes, then you will be whitewashed, but you are only happy to be with Kisumu for cane development purposes? You know, that needs to come out.
Chair, I think you're the one to justify that, though maybe they are tapping into the big brains which are in Kisumu for the development, for the cane development.
Thank you very much, Madam Chair.
Senator Halwale, is it in line with the arguments that are being proffered? Okay. So Senator Wamatinga, just hold a bit to hear what Senator Halwale has.
Madam Chair, the issues being raised by the Senator of Homa Bay are real and practical. Allow me to say this, reminding the House that the upper and lower western zone produces over 80% of the sugar consumed in this country. If we take the route suggested by the Senator of Nandi, it's dangerous. Directors are elected to represent and protect the interests of their zone. So once we admit the new schedule, the issue of electing people from a different zone and then they go and represent another zone makes it operationally non-productive and helpful. Madam Speaker, if you look at this practically, the purpose of this zoning is not to give communities zones, is to give zones to areas that make geographical sense. So, for us who know where this place is, Kisumu, South Nandi, and Kericho counties are in the same geographical area. The attempt by the Senator of Nandi on the issue of election is now to represent community interests. We are not on community interests. Because, for your information, the leader of majority, for your information, transporting cane, one of the reasons why we have failed in some areas is because of the factor of transport. So if you are taking cane too far, it becomes unproductive. I request that, Chair, directors must be voted for in the zone that has been that will have been adopted.
electing directors from outside, they go to a different zone. Since this is the only time I might speak on this, Madam Speaker, I want to congratulate the committee on the exemptions that you proposed. They are very important because it admits the principle of free market economy. You cannot tie a farmer to somebody who is not helpful. That is very good. The only rider we should put there, Madam Chair, is that a miller from a different zone should not be allowed to erect a weigh bridge in another zone. The moment they have a weigh bridge in another zone, that is when poaching comes in. Thank you, Madam Speaker.
Yes, Senator Majority.
I think there's something that my good whip is missing. You see, Kericho, Nandi, and Uasin Gishu, the problem we have is that we have abundance of cane, but no mills. In the entire Uasin Gishu, Kericho, and Nandi, if you are to lump them for purposes of zoning, they only have access to one small private mill. That will not be sufficient to provide milling services to those farmers. That is why this request is coming and saying, in the delimitation of these regions, those that are in Upper Nandi, or what is being referred to here as North Nandi, and Uasin Gishu, have ability to access mills in Kakamega, you know, because there are sufficient mills that side. And those that are in the southern of Nandi and Kericho have ability to access mills in Kisumu. Because if you do that, then you give the central region, for example, us, access to 7 mills. That is both private, I think 2 that are private, and 5 that are government mills. You separate that for those that are in the north and Uasin Gishu, you give them access also to about 5 private factories. Therefore, they are satisfied. Yes. That is the whole logic behind it and why we plead with that. In fact, Madam Chair, we are making very good progress in this. Even in the other matter where we had a stalemate, Senator Omogeni and senior there, Senator Oburu, have been able to convince us. And I think we will, because we were told to earlier consult and report progress, to shift the burden of approval from the farmer to the board, such that the farmer only has to give notification. And I think it's reasonable, so that the board is notified that me as a farmer, by the way, I'll be supplying outside my zone because I don't owe any mill, I didn't take any subsidy support from any of this miller, and I feel I need elsewhere. Then it will be the work of the board to check whether what you are saying is true, as opposed to a farmer going there. And we felt that was a fair compromise, which we will redraft. Therefore, I like the spirit that is prevailing, and we request that be the guiding spirit in considering of this bill. Therefore, I support the schedules as proposed by the committee.
Now, in view of all those submissions, it appears as though the chair's work has been eased by members in their arguments by justifying the operational zones vis-a-vis the governance zones. And that also would then mean, because you are comfortable with the operational zones remaining as operational, governance zone remaining as governance zone for purposes of elections, then we should proceed on as we had agreed. So I put the question that the new schedule be now read a second time. Division at the end. Yes, that's the new schedule.
Clause 2.
Chair, the Chair, Standing Committee on Agriculture, proceed.
Chair, I propose that the clause 2 of the bill be amended by inserting the following new definition immediately after the definition of sugarcane manufacturers. Apex body sugarcane zone means a geographical area as set out in the second schedule where growers and millers are restricted to deliver and receive cane respectively.
I propose the question that clause 2 be amended as proposed. I put the question that clause 2 be amended as proposed, division at the end. Read the next one.
The title and clause 1.
I propose the question that the title and clause 1 be part of the bill. I put the question that the title and clause 1 be part of the bill, division at the end. No.
Yes, we are done.
Yes.
Because we were formally in session when the chair directed that there be a reconsideration of clause 19.
Have you reconsidered?
Given that we have reconsidered and consulted, and that idea of notification as opposed to an approval seems to find favor amongst everybody in the room, can the chair commit then to have a redraft of that so that then tomorrow as we conclude on the same, that is a question that is put.
Chairperson, Agriculture, you have heard the request. Can you make the undertaking on whether you have been updated on the consensus position?
Thank you very much, Chair. I've been well guided on that one. I think as a committee, we accept that as a good compromise. And I think, yes, we can have it tomorrow to be part of the proposed amendments. Thank you, Chair.
So, Chair, you will get the redrafted clause 19A and 19B. We are not ready to proceed on from that point, so we will now report progress of how far we are. Senator Wakoli.
Honorable Chair, I beg to move. Honorable Chairperson, pursuant to Standing Order 153, I beg to move that the Committee of the Whole do report its consideration of the Sugar Bill National Assembly Bills number 34 of 2022 and seek leave to sit again tomorrow. Thank you, Chair.
I put the question that the Committee of the Whole do report its consideration of the Sugar Bill National Assembly number 34 of 2022 and seek leave to sit again tomorrow. As many as are of that opinion say aye. Aye. As many as are of contrary opinion say nay. The ayes have it. So, Senator Kajwang, initially we had deferred the reporting of the progress by the Committee of the Whole on the County Boundaries Bill, Senate Bills number 6 of 2023. I now invite you to report progress.
Honorable Chairperson, pursuant to Standing Order 153, I beg to move that the Committee of the Whole do report progress on its consideration of the County Boundaries Bill, Senate Bills number 6 of 2023, and seek leave to sit again tomorrow.
I put the question that the Committee of the Whole do report progress on its consideration of the County Boundaries Bill, Senate Bills number 6 of 2023, and seek leave to sit again tomorrow. As many as are of that opinion say aye. As many as are of contrary opinion say nay. The ayes have it.
Mr. Speaker,
Honorable Senator Kajwang, Senator Majority Leader. We are now reporting progress on the County Boundaries Bill, Senate Bills number 6 of 2023. Senator Kajwang. No, Chairperson.
Okay. Honorable Speaker, I beg to report that the Committee of the Whole has considered the County Boundaries Bill, Senate Bill number 6 of 2023, and seeks leave to sit again tomorrow.
Mover.
Honorable Speaker, I beg to move that the House do agree with the committee on the said report.
Do a second.
I second.
Honorable Senators, I propose the question that the House do agree with the committee in the said report. I put the question that the House do agree with the committee in the said report. As many as of the similar opinion say aye. Aye. As those of contrary opinion say nay. The ayes have it. Now on the sugar bill, National Assembly Bills number 34 of 2022. Chairperson.
Honorable Speaker, I beg to report that the Committee of the Whole has considered the sugar bill, National Assembly Bills number 34 of 2022, and seeks leave to sit again tomorrow.
Mover.
Honorable Speaker, I beg to move that the House do agree with the committee in the said report.
Do a second. Senator Oburu.
I call upon Senator Oburu Odinga.
I second.
Thank you. Honorable Senators, I propose the question that the House do agree with the committee in the said report. I put the question that the House do agree with the committee on the said report. As many as of the similar opinion say aye. Aye. As those of the contrary opinion say nay. The ayes have it. So next order, clerk.
Order number 11, motion, status of pending bills in counties.
On this motion, Senator Karungo Dhangwa, you had 9 minutes. 9, only 9 minutes. You trace your balance of the minutes.
Thank you very much, Mr. Speaker. I rise to support this motion that we as a Senate, we need to do something about the pending bills, Mr. Speaker. And as you know, it is a high time we stamp our feet as a Senate, Mr. Speaker. The reason why I'm saying that is that pursuant to Article 96 of the Constitution, we are supposed to protect the interest of the counties and its governments. And Mr. Speaker, in that, it means we have to protect our people. And our people, the citizens that we represent, that woke up very early to vote for us, Mr. Speaker, they have been working for the counties. But the counties are not paying their money, Mr. Speaker. Mr. Speaker, the people of Kenya, and especially from all over the counties, especially the contractors, once they work, they are not paid by the counties, and the only remedy is to go to court, Mr. Speaker. And when they go to court, Madam Speaker, and when they go to court, they give the governors another opportunity to embezzle, to steal, because it is through the lawyers again the governors are able to get their monies, Mr. Speaker. Madam Speaker, we need as a House to ask ourselves, do we stop everything and just discuss this pending bill? But before we stop everything, we need to ask ourselves again, how do these county governments accumulate these amounts of pending bills? One, Madam Speaker, it is to overproject their own source revenue, overprojecting, thinking that they would collect more, but they collect less, yet they had committed that amount into some contracts, Madam Speaker. Kiambu has been mentioned in this motion as one of the counties with huge amount of pending bills, amounting to 5.7 billion, Madam Speaker. 5.7 billion is an accumulation of pending bills from the 3 governors who have been there, including the current governor. And now as we speak, Madam Speaker, I know, and I'm not a prophet of doom, by the end of this financial year, which is ending in June 2024, Kiambu County will have more than 10 billion as pending bill. Why? Because the county overprojected that they are going to collect about 8 billion, yet so far they have collected less than 2 billion, Madam Speaker. Madam Speaker, another reason why we have pending bills is county governments not following their budget lines, not following their budget votes, not following what the MCAs have already passed in the budget-making process. They do requisitions to the controller of budget. The controller of budget release their monies, but once the money hits the county accounts, it is diverted, Madam Speaker. Because you would ask yourself, why would a county have a huge wage bill, have a huge pending bill, and they have not even paid their employees, Madam Speaker? And as I said, as an example of my county, Madam Speaker, that the employees, those who work at the hospitals, the casuals, the subordinates, Madam Speaker, they have not been paid for the last 6 months. So sometimes you ask yourself, do we include this kind of salary delays as part of pending bills? Remember, when the issue of pending bills was done, or this accumulation of money, they omitted, I don't know whether by choice or by omission, the monies that county owe to the pension schemes, Madam Speaker. This government or this county government, they deduct salaries from the employees, but they never remit these amounts to the pension schemes, Madam Speaker. And Madam Speaker, contractors are suffering all over. Contractors and service providers are suffering. And as I was saying earlier, the court gave them authority to auction county government properties, Madam Speaker. We don't want to get there, because I wouldn't want to see a governor driving to work only to be stopped by auctioneers and his car taken so that it can go and pay this kind of pending bills, Madam Speaker. I don't want to see a CEC, a chief officer of a county, driving a county government vehicle, stopped on the road, Madam Speaker, by auctioneers, and then that vehicle goes. Because who is going to hurt more? It is the people that we represent. Madam Speaker, can you imagine an ambulance, which is a government property, taking a patient somewhere, and the auctioneers, you know, they don't know boundaries. They stop such an ambulance, they take that vehicle to pay some pending bill for somebody who had gone through auctioneers to auction government properties, Madam Speaker. We don't want to get there. And that's why as a Senate we are discussing this issue. And once we are discussing this issue, we should actually form an ad hoc committee, Madam Speaker. Or we task the Budget and Finance Committee to investigate further and make government commit themselves on individual capacity or as governors in respective counties, Madam Speaker, so that we can deal with this issue for once and for all. Madam Speaker, the senators have been always in the dark when it comes to the usage of monies in the county. And I propose that, Madam Speaker, that we as the senators should have access to even IFMIs of our respective counties, not to pay, not to withdraw, but read-only access, so that I can be able to know what is happening in my county on daily basis by just logging in and looking at what the county is doing. Madam Speaker, the senators should also have read access only to the IB banking of our respective counties, Madam Speaker, so that we can be able to see what the governors are doing. Because sometimes we have been rendered as morticians, Madam Speaker, when we scrutinize the work that has been done by the previous governors, previous years, and we are unable to scrutinize the current governors. We can only do so on individual capacities, Madam Speaker. You know, we wait for the Auditor General to do the audit report. We look at the audit report, and then we scrutinize. So if the auditor says this was not addressed, this was not resolved, that is when we look at it. But when the Auditor General or the audit report says this was resolved, we cannot go on asking questions. So that tells us we only rely with the Auditor General, Madam Speaker. But I'm happy to know that nothing stops this House. If we want the Auditor General to look at a specific issue, we can always write to the Auditor General through this House and make sure they can look at a certain or a particular issue within this period that the governors are sitting, Madam Speaker. Madam Speaker, on this issue of pending bills and, of course, the audit report, we should also ask ourselves as a Senate, do we change the law or do we come up with a framework that every governor, before they leave office or by the time they are coming to leave office, they should defend their audit reports? That no governor should defend the audit report of a previous governor, Madam Speaker. And if we do that, we will do justice to the governors. Because I remember there is a law that has been proposed here that those who have been governors should not run for Senate, should not run for MP, and I don't agree with that, Madam Speaker, because of course we do not oversight as individuals, we oversight as a collective house, as a Senate. So instead of coming up with that law to bar governors from running for the seat of the senator or the seat of the MCA or the seat of MP, we should come up with a law that before any governor leaves office, they should appear before the Senate and defend their previous audit reports, Madam Speaker, and as well, handing over. I think they should always have a handover report, and that handover report should be given to the Senate, so that the new governor, or the governor who will be taking over, Madam Speaker, will be able to have a well-articulated, looked at, investigated, informed report, Madam Speaker. So it is a high time this Senate of
Senator Eric Okongo Mugeni.
Thank you, Madam Speaker, for also giving me an opportunity to make a contribution to this very, very important bill. Madam Speaker, I don't think there is any county in the Republic of 47 of them that is not grappling with this problem of pending bills, Madam Speaker. And Madam Speaker, when you look at the figures, they run into 100 millions of shillings. It's not a pending bill of 5 million. It's a pending bills running into hundreds of millions. Now the problem, Madam Speaker, and here is where we need to be very candid as senators. We know the root cause where we have pending bills. The first major problem is if a governor leaves office and a new governor takes over, they want to abandon all the projects that were done by the previous governor and initiate new projects, ostensibly to, I'm sorry to say, but that's what is out there, ostensibly to solicit for bribes from the new projects. And in the process, Madam Speaker, you go to counties and find very important projects that are supposed to provide services to the people of that particular county, stalling for a long period of time, Madam Speaker. I can give you an example for my county of Nyamira, Madam Speaker. We had a first governor, the late Nyagarama, who had a fantastic idea. He put in place a project to put a county, an 8-bed extension of an amenity ward in our county referral hospital in Nyamira, Madam Speaker. And unfortunately, he passed on in 2020 during the COVID period. Madam Speaker, that project has remained incomplete up to today. To date, it's not complete. Our county headquarters remain incomplete to date. And I've been in sessions where we have summoned the governor to Nairobi. I've sat with a committee that is chaired by Senator Kajwang. He can bear me witness. That governor has given an undertaking. I know maybe he doesn't go to church, he doesn't believe what he says, but he has given an undertaking that those projects will be completed. But up to date, they remain incomplete. And they're not, if you read the auditor's report, it says the people of Nyamira are not getting value for money. I was in the committee of Senator Kajwang when he promised that in 6 months, he said Manga Stadium, Manga Stadium will be ready, and he said even the Olympic trials can take place there. On oath, and he was on oath. And Mr. Speaker, he's my senior, he's an elder in our community. He was born in 1960. I'm much younger. So when he says something before a committee of the Senate and on oath, and nothing has happened. Senator Kajwang, if I take you to Manga, the people of Kitutu constituency are still crying, Madam Speaker, because they look at the 100 millions of shillings. You saw the auditor's report that has been pumped into that project, and there is nothing, Madam Speaker. So in the process, you find that you have sent money to counties. We fight here when we are sharing revenue, but the moment that money reaches our counties, it's never used for the intended purposes. The other day, we were talking about 110 million shillings, Madam Speaker, that was given to us by the national government during the COVID period. Again,
we started a project. If you read through the file, you will find correspondence from our county government telling us that, you know, we have started doing a project where we are going to build 300 bed capacity as an emergency response to COVID. If you go to behind our county referral hospital, Madam Speaker, the last time we made a visit, a committee that was chaired by Senator Mandago, we found a project that was abandoned. As soon as the new governor took office, after the death of the late Nyagaram, that project was abandoned, Madam Speaker. We had pumped in millions of shillings, and then you just abandon the project. Honestly, we are the people's representative. We are the people's representative, Madam Speaker. We must get a solution to this problem. Senator Metho, you are a bright young man. We must get a solution to this problem, Madam Speaker. We cannot allow some of the money that is thrown into projects that are never completed is money that we have gotten from donors. World Bank is giving us money that we send to counties, and we do nothing. Or you find people asking bribes. Like now we have, support to do roads in Keroka, our second largest town. The money available to us is 204 million shillings. People are now falling over themselves, talking to various entrepreneurs, those who want to do that project. Now it has even moved up. From 10%, people are being told now, give 20% before we give you a tender. And this is money that your taxes and my taxes are going to be used to repay back. It's not free money, Madam Speaker. When we get that money, it must be transformative. It must transform the quality of life that the people of Nyamira are living today, for the better, Madam Speaker. So, Ethics and Corruption Commission, why I served for 5 years, they must wake up. If you talk to all these senators, there is no governor who fears EACC anymore. They are receiving bribes left, center, and right. I want to be informed by Senator
like to be
of
informed?
Kajwang. Yes.
Senator Kajwang, you can inform him.
Thank you. Thank you, Madam Speaker. Madam Speaker, I want to inform Senator Omogeni, who is a pioneer and the architect of the anti-corruption laws and instruments and institutions, that the EACC has withdrawn their officers from Senate committee sittings. For the last 3 weeks, the EACC officer who used to sit in the Public Accounts Committee has been withdrawn without an explanation. The same thing for the Public Investments Committee. And so I just wanted to inform Senator Mogeni that something is wrong with that institution that you so proudly established, you so proudly was part of the team that set it up. And we have set a meeting with the leadership of the EACC to explain why their officers have been withdrawn from the proceedings of the Senate.
Proceed, Senator.
Thank you, Senator Kajwang. The only thing I want to amend from what you have just informed me, don't invite them. You should summon them. I mean, we should summon EACC to appear before us. And we tell the country whether we are serious in the fight against corruption, whether we have actually allowed the prophecy that was given by Professor PLO Lumumba to come to reality. Professor Lumumba said, the moment we created devolved units, he said, and most of you can remember he was on TV, he said, if we are not careful as a country, we are going to devolve corruption. I mean, why, for God's sake, would EACC withdraw an officer from a watchdog body, Madam Speaker? When I served as a member of the advisory board, I was the chair. One of the sources of getting information on corruption activities was reports of the Public Accounts Committee of Parliament. And I'm sure, Madam Speaker, if
Bishop Oginde sat, if he took time, Bishop Oginde and the CEO, if they took time, come to Parliament, sit before the committee that is chaired by Senator Kajwang, they will be shocked. If they just sit through, listen to the queries raised by the Auditor General, listen to the responses, management responses from our county government, look at the amount of money involved, the money that this country is losing, they will have sleepless nights. They will not sleep, Madam Speaker, because there is a lot of almost criminal, murderous activities that are taking place in our counties, Madam Speaker. So I fully support this motion, and I hope when we resume tomorrow, we must agree that issues dealing with pending bills is a cancer that we must diagnose and deal with once and for all as senators. I support, Madam Speaker.
Thank you, Senator. Senator Methu, do you want to give yourself the floor when the chair is holding the House?
I heard you call me Madam Chair, and I want to make the best out of the 5 minutes that I have before we adjourn, Honourable Speaker. And Honourable Speaker, as a member who sits in the Public Accounts Committee, I would want to say that when we speak about pending bills, as I rise to support this particular motion, Honourable Speaker, we must first define what pending bills are. Pending bills is somebody who has taken his or her own money, a person who has taken a loan, gone to a county like Nairobi or the counties that have been cited here, done a road with his own money, done a hospital with his own money, delivered pipes with his own money, done a classroom with his own money, and has not been paid their own money. Honourable Speaker, as we speak about these pending bills, my chairman is there, Honourable Kajwang, and he will tell you that when we look at these pending bills, every report of the Auditor General has a liner that makes most of the counties never to get an unqualified audit opinion, because, Honourable Speaker, every county has a line that is called account payables, that is the line that has pending bills. And Honourable Speaker, this is a matter that has been spoken about in this House once, many times, and in 2014, 2015, and you know it, the then Auditor General, Dr. Edward Ouko, carried out an audit to show the pending bills that are there in the counties. And as to this moment, Honourable Speaker, in all the counties that we have, 47 of them, none of the counties will say that they have a clean bill of records, Honourable Speaker. I ask myself every time, and I ask every time I sit in the Public Accounts Committee, my chairman is there who will confirm. When we have a pending bill that is sitting in your bills since 2013, since 2014, then you say that there are no documentation. Then you must either declare that a bad debt or say what you want to treat, how you want to treat that pending bill. Tell us whether a road was done or it was never done. Honourable Speaker, I want you to conceptualize it this way, Honourable Speaker. How long is a Maram road expected to last? If you did a road in 2013 and you are being told that they are going to verify 14 years later or 10 years or 11 years later, where will they get that road, Honourable Speaker? Honourable Speaker, every election cycle, in 2017, all the governors who got in, they had a pending bill verification committee. Every time we invite them, they will tell us that we have a pending bill verification committee. This election 2022, in every county, including my own county, Nyandarua, there was a pending bill verification committee. In every session, we say that there is a pending bill verification committee. One side of the pending bills, they say that these are the eligible bills. On the other side, they say these are the ineligible bills, Honourable Speaker. If then you have accepted and said that these are eligible bills, why are you not paying them? Honourable Speaker, there is the second issue that we need to diagnose here. How and where are these pending bills born from? One of the easiest route of the birth of these pending bills, Honourable Speaker, is the fact that most of the counties overstate or overestimate what they call their own source revenue. A county that collected 450 million, in their budget this year, they are saying that we expect to collect 990 million, more than double of what they collected in the year under review. Honourable Speaker, even if you use mathematics, even if you use science, even if you use witchcraft, there are no new systems that you've done. There's nothing new that you have, there are no new taxes that you have introduced. How do you expect to double your own source? Ultimately, this one brings a hole in your budget. How do they meet this hole? In their procurement plan is informed by their budget. So in the procurement plan of a county that has overstated their own source revenue, Honorable Speaker, they'll procure with the strength that they intend to collect more in that year under review. So what happens? When it is the end of the year, they have collected less than what they had intended to collect. So they have procured services, but nothing.
Senator Medhu will have a balance of 10 minutes when the next sitting resumes. Honorable Senators, it's now 6:30 p.m. Time to adjourn the Senate. The Senate therefore stands adjourned until tomorrow, Thursday, 25th April 2024 at 2:30 p.m.
Our leaders say that if we are not careful as a country, that this country will be led by wash. Mr. Speaker, guidelines have been introduced and proposed in this bill to ensure accountability, preventing electoral malpractices, and promoting a level playing ground for all candidates during the elections. Two, Mr. Speaker, is what has been mentioned by many of my colleagues, that is inclusive representation. I fully support the provision, Mr. Speaker, because it is crucial to ensure that all demographic groups, they included this part on the bill. I'm a bit disappointed because throughout this amendment bill, there seemed to be no clear mention of the not more than 2/3 bill requirement that has bedeviled this country for many years, and somehow it has not even come up even in this one. So, Mr. Speaker, it's a matter that as women we would be happy that we put closure to this matter so that what the people said in the 2010, during the 2010 constitution making is actually implemented. Thirdly, Mr. Speaker, is the issue of enhanced voter education. We are aware the importance of voter education before any electoral process. I endorse the amendment in the bill and emphasize the importance of enhanced voter education. Mr. Speaker, the utilization of technology. We are aware that technology is a powerful tool that can enhance the efficiency and transparency of electoral processes. I fully endorse this amendment and advocate for the use of technology and innovation in the electoral process, such as digital solutions for voter registration and results transmissions. Stakeholder collaboration with other stakeholders is also very, very important, and I support this particular amendment. Mr. Speaker, I know that there are many people who want to speak after me, and a lot of these issues have already been addressed by other speakers. I don't have to take too much time of the sitting. But I would like to address the issue of the CEO that has come up severally, of many speakers actually recommending that the 3 years is not sufficient. But the 3 years, Mr. Speaker, is in line with the mwongozo that all CEOs in Kenya, they should do a 3-year term and an additional 3-year term subject to the performance evaluation. So performance is reviewed every year, and if the performance is good, then they are able to be reviewed. So I really don't think this is an issue. So long as one CEO sits through an election, and that is always after 5 years. So thanking you very much once again. I support. Asante sana.
Let's have the Honorable Julius Ruto and then the Honorable Jared Okello of Nyando. The Honorable Ruto is not in, so.
Thank you so much, Mr. Speaker, for allowing me this particular opportunity. And sorry, Honorable Kiari and Honorable Borek were busy making noises here, and I could not listen to your invitation. Mr. Speaker, I rise in this particular noble discussion in the floor of the House discussing the amendment of the IBC Amendment Bill of 2024, which to me, I want to say that it is timely bill that has come at the right time, whereas we understand as Kenyans, we are in a process of governance period of 5 years, that after every 5 years, an election period is coming in. And as we are talking now, we are already 2 years down after election, and we are foreseeing another 3 years coming very soon, when there are burning issues that have to be cleared. One of the critical ones is the boundary review, where we know from the provision of the Constitution, it had provided a review of within 8 years after an election, or not more than 12 years. And of course, we know this year, 2024 March, marked the end of the 12th year that was provided by the Constitution, and now we are staring at a period of uncertainty as to what is going to happen, especially on those particular constituencies which the law had given what we call protected constituencies, and of course even changes in the population of the inhabitants, the parameters that have been provided in the elimination of the boundaries. And nonetheless to say, I just want to pinpoint issues that this particular amendment has put it more weight to me, that I really want to support the issues of aligning the IBC law with the ruling of the High Court, especially on definition of the chairman and or vice and or commissioner. This one was providing an ambiguity, and that is why in the wisdom of the courts of Kenya found it to be unconstitutional. And I want to appraise the committee of JLAC for finding that this is now the right time to be able to align, so that we're able to absorb some questions which were raised during the recent Supreme Court decision of the election, so that in the future elections we cannot again find ourselves in the same quagmire. It is now coming out clear that the chairman is an office, and that office shall oversight election in a given period, and more so the national elections of the presidency, and that it is now a reserve of that particular office holder, of the chairman, him or herself alone, that is going to ensure he presides over the election and end up pronouncing the results of the outcome of that election. So I want to appraise that one, that this particular amendment has captured in. Another issue is on the aspect of selection